Yes.
We have filed an additional affidavit. Let that additional affidavit come on record and it be heard at 2 p.m. Your Lordship.
When?
2 p.m. today.
I don't want.
Much obliged.
May I please, Your Lordship, my lord, I am for item number 23, my lord.
20?
23 on behalf of appellant, my lord. I have taken consent from other side. So this matter may be adjourned for the day and may be listed after vacation.
28.
23, my lord.
23. On behalf of
Appellant,
your name,
S.R. Borbuya.
SR?
Borbuya.
Mr. SR Barmuya, learned counsel for the appellant. You inform the others.
Yes, yes.
Yes, I am for the response.
Any objection?
No.
With consent from the other side, press for listing the matter. When?
Date may be after vacation.
After vacation.
Date may be fixed
And date
after
may be
vacation.
fixed.
After vacation for hearing,
Yeah.
24th July.
24.
Yes.
May I please, Your Lordship, I beg to mention for listing of one urgent CRP motion tomorrow, my lord.
Tomorrow.
Tomorrow.
How many cases? Under which column?
Supplementary list, a motion for motion.
One case.
May please, Your Lordship. Lordship, I beg to mention for listing of a matter at 2 p.m. Lordship.
What matter?
Lordship, RSA matter. We have filed an IA. Lordship, today the execution case has been is listed in the trial court. Lordship.
When the RSA was filed.
Lordship, RSA was filed in February. Lordship. There is a delay of 19 days.
Pardon?
There is a delay of 19 days, Your Lordship, and today the
Whether delay was condemned.
no, Your Lordship. For delay, I am praying, Your Lordship, today. For condemning the delay, I have filed that IA, Lordship.
Whether the case is listed.
No,
today.
Your Lordship, it has not been listed. I am praying for listing of that matter at 2 p.m. My Lord.
No, sorry.
Lordship, the execution case has
Maybe.
been fixed.
Who is responsible for the same?
Lordship,
Sorry.
Lordship, at tomorrow,
Monday.
Lordship.
Monday.
Oblige, Lordship.
May I please, Lordship?
Yes.
Lordship, I'm praying for a listing of a case hearing, part heart matters, Lordship. It was directed to listed matter 127/525.
When do you want?
Lordship. For listing, Lordship, for hearing.
When?
Lordship,
After vacation.
before vacation, Lordship.
Not before vacation. Take it that for mine.
24th July.
May I please, Your Lordship?
24th
With
July.
the consent of the other side, I beg to mention item number 26, Your Lordship. I am for the respondent.
Item number?
26. 26.
26. Mr.
M. Shah.
M.
Shah. Mehul Shah.
Learned counsel appearing on behalf of
Respondent.
respondent. Your name is not there. You are appearing for whom?
Lordship name is you.
My name is item 26, Your Lordship.
Okay. Okay.
I am for the appellant.
With consent from the other side, press for listing the matter. When?
I pay for adjournment today, Your Lordship, of the matter.
The respondents are paying for the adjournment.
Okay.
I am for the appellant.
The matter stands over for the day. For the day.
Okay, next. Adjourn.
We will not fix the matter. We will not fix any date.
24th of July.
Sorry. Resti will list the matter.
No date.
Yes.
Next.
Highly obliged.
I beg to mention, my lord, one RSA, my lord, may be taken on 24th, 24th,
For
my lord,
July.
my lord.
July.
24 June, my lord. Another matter is there, my lord, 24, and the earlier 2 occasions left over. So some urgency there. The other party is constructing housing in my land, my lord. That is all. Hearing day, my lord.
No. The Resti has already notified the coming week as motion day.
My lord, 24, 25, as your lordship want,
No,
my
no.
lord.
Only after
After
vacation.
vacation. Immediately after
My
vacation.
lord, problem is that, my lord, the houses are being constructed.
Sorry, there is already one notification of the Resti. Yesterday it was published.
I have seen.
Yes.
my lord.
May I please, Your Lordship, I beg to mention for listing of one RSA for hearing after vacation, Your Lordship.
Okay.
A date may
Okay,
be
that from-
fixed, Your Lord.
Yes.
May I please,
31st July.
I beg to mention listing of a CRP IO, my lord. Fresh case, my
When?
lord. Tomorrow, my lord. There's an urgency because the
What
matter is fixed for final argument tomorrow for the learned trial court, my lord.
My lord, the local,
We have cases, Lord. On Monday, 23rd.
tomorrow, my lord, because my lord, it is fixed before the learned trial court, my lord. Urgency is there, my lord.
Okay, it's last item. Your matter may not reach tomorrow.
My lord,
Already several cases have been fixed. Yes, madam.
obliged.
Please, your lordship, item number 16, 17, and 18. Take consent from other, the action for the lordship.
16, 17 and 18. You inform the other side.
Yes.
Miss, your
On
good name,
behalf
please.
of M. Islam.
M. Islam. Your good name, please.
A. Khatur.
Learned Counsel appearing on behalf of Mr. M. Islam, Learned Conducting Counsel for respondent number
1.
1. With consent of the other side, press for listening the matter
After vacation, fixed
after vacation.
6.
Okay.
31st July.
Yes,
May I please, Lordship, I beg to mention IS Civil 178424 and RSA 10324. RSA has already been admitted and stay was granted. But on the next date, there should be continued because execution is going on.
when,
Kindly
when,
list the
when do you
matter
want? When do you want?
next week.
Okay, take a date from me.
25th June. Items for admission, item 2, Parhat matter. Item 2.
Lordship, here, my lord, what you asked me to bring the record. I have received the record, but still there is, that note sheet is not there, my lord.
Not-
Of the note sheet is not there. I have received the record of the, without note sheet, that cannot be a complete record, my lord. They have given all the records without the note sheet, my lord. I have asked them for the complete record, my lord. It has not reached me, my lord, till date, my lord. This is incomplete. my lord.
But since 2 or 3 times
No, this is the second time.
time has been sought for to bring all this record and it is not there. So whatever the available documents are there, Lordship will decide on the matter. Matter is very simple, my lord. Since he has been suspended and again reinstated, my lord. Reinstated, whereas FR 54B has said that once the person is reinstated, meaning thereby he is entitled to full pay allowances as per the FR, my lord.
No, Mr. Secretary,
And-
you
and-
tell me whether without the document, without the file, can we adjudicate the dispute?
My lord, yes, that's true, my lord. Secondly, my lord, whatever he tries to bring the record on the basis of that impugn order, that he said that communication has been made, but the speaking order was received by the petitioner. And whereas in the affidavit filed by them, there was no signature of the petitioner, my lord. And in this respect, this honorable court was asked them to get the record. And this record, my lord, 2 or 3 times he sought for the time for placing the matter record, my lord. My lord, today also, my lord, the same thing will happen.
The Lordship will give me one chance. This is the second time seeking there. Lordship will give me one chance.
3
Lordship will
times,
fix
3 times already he's
second
not
time.
put time, my lord.
Lordship will fix it immediately after vacation. I will try my best to get all the records, my lord. Without the note sheet, it's
It's a
difficult. my lord.
pardon matter, that is why, my lord, I'm praying before Lord.
But Mr. Secretary, Learned Counsel for the petitioner and Mr. S. Boda, Learned Extending Counsel for the
PTC,
petitioner.
man.
Mr. Boda submits that though he has received some portion of the relevant file, yet the note sheet of the file is not made available to him. And as such, he prays for granting him some time so as to enable him to obtain the complete record from the respondent authorities. It is allowed for the last time.
As a last chance, my lord.
Lordship will fix it on 17th of
Recess, please the matter of 17th of July.
Further time will not be granted, my lord. Otherwise,
last-
again,
Last chance is the
Item three,
oblige, lord.
May it please your lordship. My lord, this case, my lord, I am before your lordship, aggrieved by the impugned order passed by the learned appellate court, by virtue of which my order of injunction passed by the learned trial court has been set aside. I was granted injunction by the learned trial court in a petition under Order 39, Rule 1 and 2, after hearing both sides. Now, thereafter, they preferred appeal under Order 43, Rule 1R, CPC. And in the appeal, after hearing the parties, the impugned order has been passed, whereby the order of injunction has been set aside. Order of injunction to the extent of status quo to be maintained by both the parties over the disputed Schedule 2 land. Now, I take your lordship to the first, I take your lordship to the order of injunction that was passed in my favor. If your lordship kindly sees the operative part of the order of injunction passed in my favor, the order of injunction starts from page number 69. In fact, 70. And the operative part, if your lordship kindly takes up page number 73 onwards. Now, everything has been taken into consideration, the factual metrics as well as the position of law by the learned trial court. Now, if your lordship kindly takes up from page number 73 down below, the penultimate paragraph. Page 73, the last but one paragraph, my lord. I have carefully perused the petition as well as the written objection filed by the OPs. I have also heard the learned counsel appearing for both sides at length. Before coming to the merits of the facts and circumstances of the case portrayed by either party, I would like to briefly discuss the parameters that bind an injunction, hearing, and the scope of an order of temporary injunction. My lord, thereafter your lordship will skip because it is a reiteration of the ruling of the Honorable Apex Court in Dalpat Kumar versus Prahlad Singh. The principles have been discussed. Your lordship kindly comes to the factual part down below at page number 74, existence of prima facie case in bold letters. By prima facie case, it means that there is some serious disputed question to be tried in the suit and act on the facts before the court. There is probability of his being entitled to the relief asked for by the plaintiff defendant. If we bring focus to the averment put forth in the petition and the submissions made on behalf of the petitioner, it is seen that the petitioner asserted that the OPs collected construction materials near the Schedule 2 land and also put up a few RCC pillars on the Schedule 2 land. Furthermore, the petitioner asserted that the OPs have started to attempt construction and some laborers attempted to dig the soil on Schedule 2 land and some laborers engaged by defendant number 2 to dig the land for putting RCC pillars and construction of RCC boundary wall thereupon. The petitioner has asserted that the OPs are attempting to grab the Schedule 2 land without having any right title, interest, or possession which clouded the right title and interest of the petitioner over Schedule 2 land. On the other hand, OPs denied the assertions of the petitioner and stated that there are several pattadars of second RS patta number so-and-so, and the absence of demarcation of boundary of dag number so-and-so in second RS patta number so-and-so, the petitioner not entitled to get any relief by way of injunction as prayed for in the case. The OPs also stated further that purchase of land measuring 6 katha appertaining to second RS patta number so-and-so, dag number so-and-so, with an area of 1 katha, 1 stack, and in second RS patta number so-and-so, dag number so-and-so, with area of 4 katha, 15 stacks. The said land was demarcated by boundary pillars, which were posted in presence of petitioner and other co-sharers of second RS patta number so-and-so and so-and-so. And on the basis of such demarcation, OP number 1, along with her husband, that is OP number 2, are enjoying the possession within the knowledge of all co-pattadars, co-villagers, including the petitioner. The purchased land of the answering OP number 1 demarcated by boundary pillars constructed up to ground level, which includes 19 numbers of pillars on southern side of said purchased land, and the same was constructed 3 years back. Thus, we see that a clear dispute has arisen with respect to the suit land between both plaintiff petitioner and the defendant's opposite parties. These facts shall be addressed and taken up during the course of the trial, where each party shall be given an opportunity of place forth necessary evidence to prove their stance. At this juncture, I am of the opinion that a prima facie case does exist between the two parties and that there are certain rights and liabilities of each party.
Okay,
that
that's
need-
all right.
That is in regard to prima facie
The
case.
appellate court.
Appellate court judgment, your lordship will kindly see, it starts from page number 83 onwards.
Hmm.
And your lordship
Where is the
will,
operative portion?
yes, operative part, your lordship will kindly come to page number 91, my lord. In fact, from 90 it starts discussion. The operative part, your lordship will kindly see. Your lordship kindly takes up page number 93 for a while.
Yes.
Now, in page number 93, insofar as the requirement of there being prima facie case is concerned, that, my lord, has been discussed first of all by the learned appellate court. And, my lord, that has been held to have existed. That is insofar as prima facie case is concerned. Now, that has been agreed by the learned appellate court that there is a prima facie case. Regarding balance of convenience, your lordship kindly takes up page number 95.
No,
That
no,
is the
no,
operative.
no.
Page number 95.
You come to para number 11,
Yes.
page number 93.
Prima facie case has been discussed there, my lord. Page number 93. Prima facie case is a substantial question raised bona fide, which needs investigation and a decision on merits. The court at the initial stage cannot insist upon a full proof case warranting an eventual decree. If a fair question is raised for determination, it should be taken that a prima facie case is established. Perusal of the order dated 14/12/2022 shows that learned court below held that a prima facie case does not exist between the two parties and that there are certain rights and liabilities of each party that need to be adjudicated, upon which shall be decided at the end of the trial of the main suit. Typographical mistake. Does not, it is not does not. Your lordship has seen the trial court order. Does exist was the order. Here it is a typographical mistake, apparently, man, because learned trial court has held all the three principles in favor of the plaintiff. So here it's a typographical mistake. My lord, if your lordship takes up the trial court judgment once again, my lord, your lordship sees regarding prima facie case, the satisfaction, my lord, your lordship will kindly see at page number 76.
Hmm.
Page 76.
Okay, all right.
That is.
You come to the second portion of the
Yes.
order of the appellate court.
Page number 93.
Yes.
Yes.
No. This balance of convenience.
Regarding page number, the
95.
95. Yes. That is what I was coming to page number 95, paragraph 13. Regarding balance of convenience and irreparable loss, the learned Municipal 1 Kachhar Silchar has observed that the balance of convenience is also in favor of the petitioner respondent. And if the order of injunction is not passed, then the petitioner respondent will suffer irreparable loss and injury if the nature and feature of the disputed land is changed, which cannot be compensated in terms of money. Learned counsel appearing for the appellant's OPs has submitted that after purchase of the land measuring 6 katha pertaining to second RS patta number so and so, dag number so and so, with an area of 1 katha 1 chatak and in second RS patta number so and so with an area of 4 katha 15 chataks. The said land was demarcated by boundary pillars, which were posted in presence of the petitioner and other co-sharers of second RS patta number so and so in the year 2016. At that time, neither the petitioner respondent nor any other pattadar had raised any objection, but suddenly after a long gap period, the petitioner respondent has come up with the main suit along with the injunction prayer, which is not maintainable at all. I have thoroughly scrutinized the materials on record, the pleadings of the parties, and the photograph of the spot available in the record. It appears upon perusal of the averments of both the sides, as well as the photograph available in the record, that the pillars and apparently are apparently posted long back, and those are not new posts as alleged by the petitioner respondent. Besides, as revealed from the pleadings of the OP's appellants and submissions of the learned counsel, the OPs are enjoying the possession within the knowledge of all co-pattadars and other co-villagers, including the petitioner respondent. Hence, under such circumstances, granting injunction in favor of the petitioner respondent would cause great inconveniences and loss to the OP's appellants. Further, upon close scrutiny of the entire materials on record, it appears that in the event of grant of injunction or in the event of refusal of the injunction prayer, That is, in either ways, the OP appellants would suffer loss and injury more than that of the petitioner respondent side. Hence, the learned court below has committed error while holding that the petitioner respondent would suffer irreparable loss and injury, and that the balance of convenience tilts in favor of the petitioner. Hence, considering all the aforesaid highlighted aspects, I'm of the opinion that in a case like the present one, passing an order directing both the sides to maintain status quo with regard to the Schedule 2 land from causing any change in the nature of the said land by way of any construction work over the said land, effective from the date of passing of the said order till the final disposal of the main suit, appears to be not just and proper. Considering the discussions made in foregoing paragraphs, it is found that there is infirmity in the order dated 14/12/2022 passed by the learned Munsif 1 Kathar Silchar in mistake case so and so, which requires interference by the appellate court. The point of determination is decided accordingly. So now, excuse me. Now this is the finding of the learned appellate court. Now, your lordship will kindly consider one aspect of the matter. Here, the dispute is in regard to Schedule 2 land. And so far, Schedule 2 land is concerned, the pleaded case of the petitioner before the petitioner and the plaintiff before your lordship is that this land was purchased by the plaintiff petitioner by registered sale deed number 214 of 1998, dated 24/4/1998. The lordship will kindly take note of the date.
Schedule
2 land. It is our pleaded case that it was purchased by the registered sale deed number 214/98, dated 24/4/1998. And it is also an admitted fact by the respondents herein by way of their written statement that they have purchased their land that they are claiming and which we say is an encroachment upon Schedule 2 land. Their claim is their purchases on 20/12/2016 by way of sale deed number 18, and that sale deed number 18 was registered on 6/1/2017. This is their pleaded case. So apparently, over a land which is under dispute, I claim to have purchased it by way of a registered deed prior in point of time, prior in point of time in the year 1998 by way of a registered deed. And this is the land which they say, and they come up with documents to substantiate that they have purchased it in the year 2016 and which got registered, the title deed got registered in the year 2017, 6/1/2017 to be precise. So from that point of view, my lord, so far our claim as regards right title interest is concerned, that also, my lord, is prior in point of time when we go to substantiate the same by way of a document. That document has not been challenged. That document is also, my lord, is an evidence which obviously will be taken care of and appreciated during the relevant stage of the trial. Now, so far as their claim of having constructed certain pillars over the Schedule 2 land is concerned, now they are saying that they have constructed it long back. And to that extent, before the learned appellate court, they have come up with certain photographs. And by a bare eye perusal of the photographs, the learned appellate court has come to the finding, without testing the veracity of such photographs, that these are old pillars. These are not new pillars. Now, whether the learned appellate court can arrive at such satisfaction by merely seeing the photographs with the naked eyes, that it is an old pillar, it is not a new pillar. That is my first point of argument. And my second limb of argument, my lord, is here our categorical plea in our objection, in our injunction petition, as well as in our suit is that, yes, they started raising construction sometime in March 2022, which we stopped through police intervention. This is our pleaded case, that in March 2022, they tried to start construction. And in fact, they were successful in raising a few pillars, that is true. And because of which we straight away approached the police, and through police, we got that construction stopped for that particular time being. Then again, in the month of September, precisely 13/9/2022, we have categorically mentioned the date. They again started construction, because of which we approached the learned court below by way of suit, where we prayed for declaration of right title interest and confirmation of possession. If they are under possession, we would have sought for recovery of possession. In our suit, we have prayed for confirmation of possession. So here, this is also another valid aspect, my lord, which goes on to tilt the balance of convenience in my favor. I have in my suit not prayed for recovery of possession. I have in my suit prayed for confirmation of possession. So meaning thereby my possession is with me. They tried to encroach it. They were stopped initially by the police. Thereafter, they again attempted. Thereafter, we came before the learned court below in our suit, where we have prayed for declaration of right title interest and confirmation of possession, and we have prayed for injunction to the extent of maintenance of status quo over the suit length is the adjudication of the suit. And that was considered by the learned trial court. My lord will kindly just have a look at the essence of the order of the learned trial court while adjudicating the injunction petition, taking note of all the three cardinal principles. My lord will kindly see, your lordship kindly sees at page number 78. Page number 78, if your lordship kindly sees, the third paragraph from the bottom. May I read the paragraph, my lord? To sum up
Not
the
necessarily, the principle is already well settled.
my lord, and at the same time, the finding, the last observation that has been made is that till the disputed land, the claim over the disputed land is decided, status quo is to be maintained, lest the nature and feature of the land would change, and that will cause irreparable loss and damage. So infirmity insofar as this order was concerned, my lord, in my humble contention, I don't find any infirmity insofar as the order of the learned trial court is concerned. But when it came to the findings of the learned appellate court, and when it came to one particular my lord, finding of the learned appellate court, I have not been able to
Mr. Chakravarti, you come to the grounds
grounds of the appeal,
ground of this petition, civil reason.
my lord, my petition. It starts from page number 14, my lord. And
What are the main grounds?
my lord, my main ground, my lord, would be the ground number 3, my lord, insofar as their claim of construction of pillar, a demarcation of boundary, my lord, is concerned. Here I have stated, for that the learned appellate court exercises jurisdiction illegally and with material irregularity in taking the version of the respondents, defendants in their pleadings as regards their claim of purchase of the suit land with demarcation of the same by boundary pillars without any objection from any corners, etc. in adjudicating the issue of injunction at the appellate stage, although such factual metrics are yet to be proved by leading evidence in the suit, and in doing so the learned appellate court has committed jurisdictional error, and as such the impugned judgment and order allowing the appeal should be set aside. My lord, that is so far their claim of demarcation of the boundaries are concerned, of the boundary is concerned, that to that extent, my lord. And another vital ground, my lord, at page 16, ground number 6, my lord, if your lordship kindly sees. For that, the learned appellate court did not attach credence to the pleadings of the petitioner plaintiff in the injunction petition to the extent that the petitioner plaintiff is the legal owner of Schedule 2 land by virtue of purchase by registered sale deed number 21498 in the year 1998 and has been in possession over his land ever since. On the other hand, despite the admitted position of the fact that the respondents defendants had purchased the land claimed by them from their vendors in the year 2017, the learned appellate court has exercised its jurisdiction illegally and with material irregularity in arriving at the findings that the respondents defendants have been possessing over the suit land since purchase and grant of injunction over the said land would rather cause greater loss and injury to the respondents defendants. As such, the impugned judgment and order is bad in law. Now, insofar as the construction of pillars, if your lordship kindly takes up at page number 18, ground number 8. Page number 18, ground number 8. Further, the learned appellate court took the version of the respondent defendants as regards demarcation of the purchased land and construction of pillars thereupon as gospel truth. However, there is no reason assigned in the impugned judgment and order as to why the version of the petitioner plaintiff was not taken into consideration, though it was categorically pleaded that the pillars were constructed during March 2022, which was stopped thereafter due to intervention of police. But again, when the respondents defendants attempted to construct pillars on the suit land, the suit was filed along with the injunction petition. Such apathy of the learned appellate court to the pleaded case of the petitioner plaintiff is perverse, illegal, and materially irregular, and is therefore liable to be set aside and quashed. Now, again, my lord, one more ground your lordship kindly sees in regard to the principles of injunction, page 19, paragraph number 10. Page 19, paragraph number 10. Further, the learned appellate court miserably failed to point out any arbitrariness, caprices, or perversity in the order of status quo passed by the learned trial court, which had rightly held that there is a dispute between the parties as regards Schedule 2 land, and the petitioner plaintiff apprehends that the respondents defendants shall change the nature and features of the suit land, and if the suit property is not preserved, and in the case the petitioner plaintiff succeeds in establishing his claims made in the suit, it will cause substantial injury to the petitioner plaintiff, and as such the balance of convenience is in favor of the petitioner plaintiff, because the loss of the petitioner plaintiff would be far greater as compared to the loss that the respondents defendants might suffer if the situation were left untouched. In fact, the learned appellate court has arbitrarily, capriciously, and perversely interfered with the order of status quo passed by the learned trial court, though the said order was in total adherence to the three cardinal principles of temporary injunction. As such, the impugned order judgment is liable to be set aside and reversed. So these are the grounds I have taken, my lord, because these were very comprehensively discussed by the learned trial court in passing the order of injunction to the extent of maintaining status.
Yes, Mr. Protester.
May I please, lordship? No. It is settled, lordship, that mere prima facie case is not sufficient. There must be irreparable injury. Now, if I could follow argument of my learned brother, he has admitted that there is some pillar constructed. There, he is saying that it was subsequent. Our case was that our pleadings was that it was 3 years back, in which we have submitted certain photographs, and learned appellate court also considered that. Now, when there is a pillar constructed by us, it is apparent that it is under our possession. So balance of convenience cannot be in his favor, it is in our favor. So we will sustain irreparable loss, lordship. I'm just telling up one decision, lordship, regarding this, lordship. Cause of action and prima facie case is different. Yes, sir. I have relied upon the bestseller case, lordship, paragraph 14, kindly once. Paragraph 14, it's page 4. Yet the settled principle of law is that even when prima facie case is in favor of the plaintiff, the court will refuse temporary injunction if the inquiry suffered by the plaintiff on account of refusal of temporary injunction was not irreparable. Thereafter, satisfaction that the prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequence of apprehended injury or disposition. So, admittedly, there is some construction, that means it is in our position. There is no irreparable injury the plaintiff could show in his favor. Now, the prayer, my learned brother has submitted that he has only prayed for confirmation of possession. Now prayer at Lordship page, it is 29 of the plain, prayer number B. They are saying confirmation of possession of the plaintiff over the Schedule 2 land and alternatively for recovery of first possession. Page 29.
Page number
Page 29.
29.
Top B, small b.
Yes.
Confirmation of possession of the plaintiff over the Schedule 2 land and alternatively for recovery of cash possession of Schedule 2 land by evicting the defendants and dismantling the RCC pillars and other construction therefrom in the event of the plaintiff is forcefully ousted and any illegal construction is done during pendency of the suit. So they know it is a art of drafting, Lordship, that when we know that we are not in possession, we insert in prayer that if during the pendency, if we are, they know they are in possession, and it is apparent from the submission of my learned counsel for the plaintiff petitioner also. So they have also paid for recovery of possession, which also shows that they are not in possession.
No. But
They are
have
saying
also
during the
mentioned-
pendency of the suit, during the pendency of the, they are saying, but again they are saying that we are in, there is construction by us. So that means they have been, if there is any encroachment or disposition, it has already been already has taken place. Now, whether there is a disposition or not, it will prove, it will be proved in trial. But from that, it is there. So, this is my submission, Lordship. There is no irreparable injury in favor that plaintiff will suffer. Only prima facie case is not sufficient. Therefore, there is no infirmity in the order of the learned appellate court.
Okay.
Well, just to reply one aspect, my learned brother is trying to take handle of my prayer at paragraph B, prayer number B. It's very clear it is in the event of there being any disposition, only then I am making a conditional prayer that in that case I may be given recovery position. It is not my main prayer, so he cannot take a handle of that. And my lord, my reliance would be on the famous celebrated ruling of Dalpat Kumar, my lord, if I may just place.
No, regarding principles
My
of
lord.
granting injunction, there is no dispute.
That's all, my lord.
And that is well settled.
My lord, Dalpat Kumar has settled it once and for all, my lord. That is being, even in bestseller also, Dalpat Kumar has been reiterated.
Referred to.
Yes. Only
We'll
one,
pass the order.
Lordship, only one thing may I add, Lordship. Everything is dependent upon trial. Now, apparently, we are in position. If we construct or we are in position, if he gets a decree, it always there, execution.
Other way
He
around.
has to show irreparable injury.
Other way around.
Much obliged, Lordship.
Obliged.
For bail hearing item 4.
May please, Lordship. This is a third application, Lordship.
Third application.
Lordship. Now,
So, what is the ground in filing this third application?
Lordship, the prolonged incarceration is one of the ground, and the main ground is the ground of arrest, Lordship. Lordship,
No,
I am-
first you tell me, more or less I am acquainted with the facts because earlier to bail application was dismissed by this court.
Yes, Lordship.
Now you tell me, where is the guarantee that if you have been released from jail, you will not commit similar offenses?
Lordship, this is his first offense. I hope my learned friend would also not be able to show anything that he is a habitual criminal, Lordship. This is his first offense, and that too happened in sudden provocation. He had no intention, Lordship. He had no intention, and he is
No,
repentant.
what intention is required? In broad daylight, you have
Yes,
put
Lordship.
one dagger into the chest of another person.
That was to save him because he was a
save
drunken mode
him.
at that moment, Lordship.
What arms was with the other person?
Lordship, he was in intoxicated mode, Lordship, at that moment. Some other person came to attack him because he went in a puja mandap, Lordship, under drunken condition. Therefore, some people came to attack him, and at that
Mr.
moment the thing happened, Lordship.
Mr. Hussain,
Lordship,
we are granting you liberty
Lordship.
to agitate these issues before the learned trial court. You go there and
Other Lordship,
That
Lordship
was
is
the-
aware about the our Lordship. We have filed petition, Lordship, before the learned trial court, and that is rejected on 10/4/25. I have annexed that order also, Lordship. 10/4/25, page 23.
Okay. Heard Mr. M.I. Hussain, learned counsel for the accused, and also heard Mr. P. Borthakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is referred by accused Krishna Sil, who has been languishing in jail as in connection with session case number 27J of 2023, corresponding to Yugi Gupta PS case number 94 of 2023, under section 302 of the IPC, pending before the Court of Learned Additional Session Judge within the FTC, North Salmara, Waverly, for grant of bail. Mr. Hussain, learned counsel for the petitioner for the accused, submits that this is the third bail application prepared before this court, and the earlier two bail application being, what is the order?
Lordship, page 15, page 15 and 19.
And the earlier two bail application being BA number 2782 of 2023, dated 24/8/2023. No, was dismissed by this court by order dated 24/8/2023. And the second bail application being BA number 1015 of 2024 was dismissed by this court by order dated 24/4/2024. And this third bail application is preferred on the ground that the accused has been languishing in jail as for how many days?
832 days as on today.
For 832 days. 832 days. And also on the ground that the ground of arrest has not been communicated to him at the time of arrest by the arresting officer. Arresting officer.
I have annexed the copies,
And
Lordship.
further, Mr. Hussain submits that the case is pending at the stage of trial.
Yes.
And out of how many witnesses?
Out of 16, 10 are examined, Lordship.
Out of 16 witnesses, 10 witnesses have already been examined. And that the accused will appear before the learned trial court on each and every date. And therefore it is contented to allow the petition. On the other hand, Mr. P. Borthakur. Yes, Mr. Borthakur.
Yes, my lord, now he has not raised all these points before the trial court, my lord. And in fact, my lord, during the rejection of the bail application order by the trial court on 10/4/25, and my lord, I would like to point out, my lord, during pendency of the present case, my lord, another BA was also pending before the trial court, which was rejected by the trial court on 3/6/25. All these, my lord, issues were not raised before the trial.
This application.
Yes.
No, last application was
Yes, my lord, I
rejected
have
on-
flag marked, my lord, on 3/6/25. My lord, that bail petition was again rejected. During pendency of the present bail petition, that bail petition was rejected. My lord.
So when did you file this petition? Before the trial court?
Lordship, it was rejected on 10/4/25, Lordship, page
No, this
22.
petition dated, order dated 3/6/2025.
3/6/2025. 3/6, and I have filed this petition.
Perhaps you have filed an affidavit here that no bail petition is pending before the. before any other
28th day of May, Lordship. I filed this petition on 28th day, 28th May.
28 May.
28.
Thereafter, how this order came to be passed by the learned trial court? Mr. Borthakur, have you seen this petition here? Petition number 1436 of 25?
Yes, my lord, 1436 only rejection order, my lord, I have gone through the rejection
No,
order.
no, have you seen the petition here?
Petition, my lord, I have not gone through.
Perhaps in that petition, he filed an affidavit there that no other bail petition are pending before
regarding
the,
that bail
before
pe-
any other course.
Bail petition, that bail petition, I will have to search, my lord.
If you go through it, if necessary, we will pass an order for inquiry. How you can file two bail application at the same time before two different courts?
Lordship may pass the Lordship may mention that part in the order and direct the learned trial court to.
No, we'll
on
see.
that.
If you are not approaching this court with clean hand, then definitely we will impose some cost.
Okay.
Standing item 1 for motion.
May it please your lordship, regular bail application. During investigation, your lordship had rejected the bail. Subsequently, my lord, after completion of investigation, the accused was granted bail by the learned trial court, my lord. Thereafter, your lordship will find that at page 25. This case of theft of rupees 11,500, my lord. Page 25, my lord, he was granted bail by the learned session judge on completion of investigation, my lord. Now, your lordship will kindly come to page 34.
When this court was placed to reject your petition?
Well, that was rejected during investigation stage, my lord. Considering
Tell me
the
when? I am asking
oh,
you
my lord, when, my lord, 3/1/24, my lord.
Where is that order?
My lord, page 45 of the additional affidavit, my lord. Page 45, my lord.
Yes.
Yes, my lord. Your lordship, relevant portion, your lordship, page 47, para 8, my lord. Your lordship held that this court is of the view. This is not a fit case where the privilege of bail can be granted to the accused. Accordingly, the bail application stands dismissed at this stage. So this was rejected on 3/1/24. Subsequently, my lord, at page 25, on 17/1/24, charge sheet was submitted, my lord. So we filed another bail application before the learned trial court. The learned session judge, my lord, granted bail. Thereafter, my lord, will kindly come to page 34. The case was committed, my lord, and after committal on 29/11/2024, I appeared before the learned trial, learned court of session judge, my lord, and I was allowed to go on fresh bail. Again, my lord.
Page number
Page 34, my lord. Yes. Now, my lord, thereafter, page 36. On the next date, my lord, I was absent with steps on page 36, my lord. Thereafter, my lord, next 2 dates also I was absent with steps, my lord. Page 37, 5/2/25 and 11/3/25, my lord. Thereafter, my lord, on page 38, on the 4th date, I was again absent, but with steps, my lord. However, this time the learned trial court, my lord, rejected my absent petition and issued NBWA against me. Thereafter, my lord, on the next date, 9/6/25, I appeared. I was not arrested. I appeared before the learned trial court and I prayed for allowing me to go on fresh bail and to recall the NBWA. That is at page 39, my lord. This was rejected and I was taken into custody, my lord.
So rightly you have been taken into custody.
My lord, I admit, my lord, my
Merely
mistake.
because you have filed a petition for adjournment, that is not the ground. That case was fixed for consideration of search.
My lord. No, there was a default on my part, my lord. I admit, my lord. I have learned my lesson, my lord. Henceforth, my lord, I will regularly appear on each and every date, my lord. Since I was already on bail, my lord, and I was not absent without steps, my lord. Steps were taken. So perhaps, my lord, a lenient view may be taken, my lord. I will appear henceforth on each and every date, my lord.
Mr. Bortakur?
Otherwise, my lord, the order passed by the learned session judge my lord, rightly has passed the order considering the conduct of the accused, my lord. And thereafter, my lord, on many occasions, my lord, on medical ground, he absent before the trial court. Although, my lord, medical ground was shown at that point in time, my lord, no document annexed in the petition regarding his, my lord, medical condition, my lord. So there is no illegality in the order passed by the learned session judgment.
Order is correct, my lord. There is one default was there on my part, my lord. But henceforth, my lord, I will not repeat it, my lord.
Whether charge was framed?
No, my lord. Case is fixed on 23rd, my lord, for charge, my lord.
Then
23rd.
again you will remain absent.
No, my lord will remain present, my lord, on each. My lord will impose a condition that if I default, bail may cancel, my lord. Without justification, if I remain absent, my lord, then bail may be cancelled.
Let the charge be framed, thereafter we will see. Or after framing of charge, you go and approach the trial court. Who will grant you liberty.
I humbly pray, my lord, that since I have been in jail for now 12 days, my lord, because of this default, my lord.
Merely because you approach this court, we will grant you bail, that is not
No, my
the
lord.
correct position.
But since, my lord, I was taking steps, my lord, but I admit, my lord, there was a default on my part, my lord, that there is no denying that part.
Charge is yet to be framed.
On my lord. Offenses, otherwise, my lord, this pertains to theft of 11,500 rupees, my lord. FIR, your lordship will find.
No, for a poor laborer, 11,000 is a vast bigger amount. She is a daily wage earner. You go and approach the trial court after framing of charge. Heard Mr. S. Nawaz, learned counsel for the accused, and also heard Safi Bortakur, learned additional people for the state respect. This application under section 483 of the BNSS 2023 is prepared by the accused, who has been languishing in jail as of in connection with session case number 31 of 2024 under section 379 120p 401 413 420 IPC since 9/6/2025. Mr. Nawaz, learned counsel for the accused, submits that the accused was solicited after completion of investigation under section 120p 401 413 420 IPC. And thereafter
379 is also there.
Read with section 379 IPC. And thereafter, the learned session judge by order dated 17/1/2024 was placed to grant bail to him after completion of the investigation. Thereafter, the learned session judge has fixed the case for consideration of search.
Case 34, my lord.
By order dated 29/11/2024, fixing the matter on 3/1/2025. But on that day, the accused remained absent with his date. The next date was fixed on 5/2/2025. On that day also, the accused remained absent. And the learned session judge has fixed the case on 11/3/2025. Then on 11/3/2025, the accused remained absent. And the learned trial court has fixed the case on 29/4/2025 for consideration of search. And on 29/4/2025 also, the accused remained absent and filed a petition for his absence. And this time the learned trial court has dismissed the petition and directed to issue non-bailable warrant of arrest against him. And fix the case on 9/6/2025. Then on 9/6/2025, the accused appeared with a petition showing the ground of his absence on the previous dates and also for allowing him to remain on previous pay.
Go on fresh bill, madam. Para 2, madam. Page 39, para 2, madam. Please to allow him to go on fresh bill.
File a petition to allow him to go on fresh bail and to recall the non-bailable warrant of arrest issued against him. But the learned session judge, by order dated 9/6/2025, has dismissed the petition, considering the conduct of the accused and taken him into custody, and fixed the matter on 23rd/6/2025 for consideration of search. And that some sort of lapses are there on the part of the accused, and that he will appear before the learned session judge on each and before the court of learned session judge on each and every day, and therefore Mr. Nawaz contented to take a lenient view. On the other hand, Mr. P. Portaker, learned additional PP, submits that by a region order, the learned session judge has dismissed the petition filed by the accused to grant him fresh bail and taken him into custody, and that the charge is yet to be framed. And if the accused is enlarged on bail at this stage, it may cause delay in disposal of the case. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also there is the order dated 9/6/2025, by which the learned session judge has taken the accused into custody, rejecting his petition for allowing him to go on fresh bail. It appears that the learned session judge has elaborately discussed the ground for taking him into the custody. And in view of the given facts and circumstances on the record, the grounds assigned by the learned session judge appears to be sound and cogent. And the conduct of the accused appears to be not at all satisfactory, and the case is fixed for consideration of the search. Under such circumstances, this court find no merit in this petition, and accordingly, the petition is dismissed. However, liberty is granted to the accused to approach the court of learned session judge after framing of search and after examination of the complainant of the Mosolpur PS case number 91 of 2023 under section 379 IPC. Redo it 120B 401 413 420 IPC in terms of this bail application is not disposed of.
Learned trial court will decide it, my lord, without being influenced by the observations by this court. Learned trial court will decide the matter, my lord, without being influenced by the observations.
In the event of filing an application, the learned sessions shall consider the same in accordance with law without being influenced by any of the observation made here.
I'm deeply obliged, my lord.
Item 4.
Otherwise, from the bail order itself reflects that no other bail application is filed or pending before any superior court. That is in the bail order itself, my lord, reflects. And that bail petition is, my lord, 146.
My lord, perhaps the bail petition was filed by DLS through LADC. And when a petition is filed by the LADC, the petitioner may not have any knowledge regarding that petition, lordship. Because the petitioner, family member or any other person may need not to be petitioner in that case, lordship. And that may also have the observation also may be there, lordship. We are not aware, lordship.
Without any instruction of whether they can file a bail application.
Lordship,
You file an
what I am,
affidavit.
what
You file an affidavit on next day. We'll see. Heard Mr. M.I. Hussain, learned counsel for the accused. Then also heard Mr. Borthakur, learned additional witness for the state respondent. This application under section 483 of the BNSS is prepared by the accused. Namely, Krishna Sil, who has been languishing in Jail Hazard in connection with session case number 27J of 2023, corresponding to Zogi Gopa PS case number 94 of 2023 under section 302 IPC, pending before the Court of Learned additional sessions as FPC North Salmara Abhayapuri for grant of pay. During the course of hearing, Mr. Borthakur, learned additional PP, has pointed out from the scanned copy of the record received from the learned trial court that there is an order dated 3/6/2025 by which the learned additional session judge Abhayapuri has dismissed one bail application preferred by the accused. And in the said order dated 3/6/2025, the learned additional session judge has observed that it is submitted by the learned LADC that except this bail petition, no other bail petition is pending in any other court, nor any petition was rejected earlier by any superior court. Mr. Borthakur submits that the aforementioned observation indicates that the learned additional district judge Abhayapuri was not informed by the accused that one bail application being BA number 1797 of 2025 is pending before this court. And as such, the accused herein have filed false affidavit before the learned trial court, before the court of learned additional session judge Abhayapuri. But in the given facts and circumstances, it is provided that the learned counsel for the accused, Mr. M.I. Hussain, shall file an affidavit under what circumstances the bail application number 1436 of 2025 dated 2/6/2025 was filed before the learned additional district judge by furnishing false information, while BA number 1797 of 2025 is pending before this court. Place the matter on Monday.
Lordship, in that case, I have to go through the record because petition was filed by LADC, Lordship.
Give the record to him.
Lordship.
Item 5.
Wait, this is your lordship. Lordship, in this case, we were supposed to file objection because the delay is too long. But inadvertently, we could not file lordship. We need some time, maybe 1 week time, lordship.
How many days?
They have mentioned
785. My lord,
Five?
785.
785.
Yes, my lord. The grounds is
but
mentioned.
that is more than, as per our calculation, that will be more lordship.
More than that.
Yes, because the judgment was passed in
Okay.
2017.
Heard, Mr.
BR does not.
B.
BR does.
PR does learned counsel for the applicant. And also heard Ms. R.D. Mazumdar, learned counsel for the respondent opposite party. For the opposite party. Ms. Mazumdar submits that she was supposed to file an objection in this petition, but inadvertently the same could not be filed. And she pressed for granting her some time. There is accordingly allowed. This is the method. Clarification.
Highly obliged, lordship.
Item 6.
Lordship, in this case also, we are appearing, our names are not shown. On the last date also, our names were not shown and he got it admitted. In the delay petition, we had appeared, lordship, in the cause list today also, and we need a copy also. He has not served us copy and he did not inform the court that we were, we are appearing in the case on the last.
My lord, as per court order, we have served the copy, served the notice as well as an ID card. And we are bound to serve the copies to the opposite party number 1 or Indian Insurance Company. We have already served that copy. So it is the duty of the their company to serve that copy to their engaged counsel.
Lordship, in the delay petition, we were appearing. He knows that we are appearing. Our names were not shown in the cause list. It was his duty to inform the court that so and so is appearing and their names are not shown. He did not do that.
My
And
lord,
now he's saying that
my
he has
lord,
sent a copy to the
at the
insurance
time of
company.
admitting the MSc appeal.
Anyway, you have extra copy with you.
Yes, I am in order sheet may be reflected.
Okay. Heard Mr. B.R. Das, learned counsel for the applicant, that is R.D. Mazumdar, learned counsel for the respondent. Appellant. Ms. Mazumdar submits that her name has not been reflected in the cause list and a copy of the memo of appeal has also not been furnished to her. Accordingly, it is provided that Mr. B.R. Das, learned counsel for the appellant, shall furnish a copy of the memo of appeal to Ms. Mazumdar during the course of the day. Further, it is provided that rest shall reflect the name of Ms. Mazumdar in the cause list and list the matter immediately after reopening of petition.
Yes.
And also name of my juniors, lordship, C. Majumdar and S. Sharma.
Okay.
Highly obliged.
Item 7.
Wait, please, my lord. Lordship, matter will be adjourned for the day, lordship. As a county council is out of the station, lordship, due to his mother health condition, lordship.
Who is the conducting counsel?
I am appearing for respondent number 1. I'll find my objection, my lord,
Okay,
in
lordship.
continuation petition.
Let them file. No problem.
In the meantime, my lord.
Lordship.
Heard Mr.
A.K. Kanu,
Learned counsel appearing on behalf of Mr.
M. Ahmad.
Learned counsel for the appellant. And Ms. Chaudhary for respondent number
1.
1. The learned counsel appearing for the appellant. Press for adjournment of the matter for the day. They are allowed. The matter stands adjourned for the day. List after 2 weeks. Or later.
3 weeks may be allowed to file objection.
You have not filed the objection till now.
I filed wakalatnama on 13th of my
Ms.
lord.
Chaudhary submits that she may be granted some time to file objection. There is accordingly allowed. This is unless the matter after 3 weeks.
Item 8.
Next, please. So I have for withdrawal of 50% deposit amount, which is already deposited by the appellant side, Lordship. We want to withdraw the said amount, Lordship.
Sir, Goswami, any objection?
Lordship, I have filed an objection, my Lordship. In this case, LCR has also been received, Lordship. It's regarding involvement of vehicle. Can it be heard immediately after the vacation, Lordship? Instead of-
Yes, but in the meantime,
The whole matter can be disposed of.
he will execute a bond.
Yes, I will execute the bond, Lordship.
Yes, Lordship.
Or if they are success the case, I will return.
Yes.
Heard.
B. Islam,
Mr. B. Islam, learned counsel for the applicant, and also heard Mr. Goswami, learned counsel for the opposite party. This interlocutory application is prepared by the applicant for allowing him to withdraw 50% of the awarded amount being deposited before the registry of his court. Mr. Goswami submits that he has filed of objection. There are taking note of the submission of learned counsel for both the parties. The applicant is allowed to withdraw the 50% of the deposit with amount before the registry of his court, subject however to furnishing a bond of equivalent. In terms of this IAS story.
Much obliged.
Can the matter be heard after the vacation, Lordship?
Okay.
LCR is also.
In recessal list the appeal immediately after reopening of the vacation. Will not fix the date.
Item 9.
Similar prayers or similar order can be passed.
I is for
Withdrawal, Lordship.
withdrawal, stay.
Stay.
Stay. You have filed additional affidavit. No, this is affidavit in opposition.
But stay
Mr.
was.
Parker, you have filed application for withdrawal. Then Mr.
No,
Goswami has filed objection.
withdrawal. Yes, mine is Lordship, stay was till this date only, Lordship.
Yes, Lord. For a limited period, Lordship, stay was granted and 50% not released. Against, at this stage, Lordship, I am praying for matter may be state and 50% may be directed to be released by the land appellant.
No, this IA number 1379 is filed by whom?
Lordship?
Who filed this IA? 1379 of 2025.
Let me apni file koi se affidavit in opposition.
1397.
1397 filed by insurance companies of appellant.
Oh, stay.
For stay.
And stay was granted.
Stay granted for limited period.
1397 is up.
Affidavit filed by
Oh, affidavit file se.
petition.
Yes, Lordship. That is a stay application, Lordship.
So 50% not released against which we have filed a petition.
You have filed IA.
No, Lordship, affidavit.
Pardon?
Affidavit filed. I have in affidavit filed in I.
This, I have not yet deposited because there is no order for depositing
Yes,
the amount.
yes,
So how can I ask for release?
No, release the authorized. Affidavit this.
In this case, Lordship, I may be directed to deposit 50% and he may be subject to bond, Lordship.
Lordship.
Making Lordship, LCR may be called on immediately, Lordship, dismiss.
No, whether the appeal was admitted or not.
Appeal was admitted.
Appeal admitted.
Appeal was admitted.
Stay was granted for certain period.
Appeal was admitted, Lordship, on 16/5/25. There is no direction for deposit, Lordship.
No.
National item of law.
Yeah, heard Mr. R. Goswami, learned counsel for the applicant. And Mr. A.P. Sarkar, learned counsel for the opposite party. This application under Order 41 Rule 5 of the Code of Civil Procedure is prepared by the applicant for staying operation of the interim judgment and award dated 8/8/2024 must be the learned member MSCP number 2 Kamrup M. In MSC case number 1365 of 2022. is to be noted here that by the impugned judgment and award, the learned tribunal has directed the applicant parent to pay the sum of rupees
34,51,373.
page number.
In I.
Lordship, page number 3, I have mentioned it, but is in the judgment page number is Lordship
43 in I.
43,
43.
45.
34 lakhs 51,000
370.
372.20 rupees.
845.
20 rupees. To the respondent, opposite, no, to the opposite party number. Mr. Sarkar, you are for
Clement Lordship, respondent number 1.
Raza Hazarika.
Yes, Lordship.
To the opposite party number 1, Sri Raza Hazarika. Mr. Goswami submits that the applicant insurance company has already preferred an appeal, the MSC appeal number
171.
171 of 2025, and the same has already been admitted by this court, and the record has also been also and and operation of the impugned judgment was stayed
Lordship,
till today. Till today. Till today. Mr. Goswami submits that the impugned judgment and award is required to be stayed till disposal of the MSC appeal, and the applicant company will deposit 50% of the awarded amount before the registry of this court. Mr. Sarkar, learned counsel for the respondent, opposite party number 1 submits that in the event of 50% of the amount being deposited before the registry of this court by the applicant company, the respondent number 1, respondent opposite party number 1 may be allowed to withdraw the same. Taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The impugned judgment and award dated so and so stands stayed till disposal of the MSC appeal number so and so, subject however to 50% of the awarded amount being deposited before the registry of this court. And the respondent opposite party number 1 is allowed to withdraw the said amount on furnishing a bond of equivalent. In terms of this highest dispose of.
LCR has not been received. LCR may be called for again.
LCR was called for perhaps.
Has not been received probably. Is it? I don't know if it has been received.
Recessal is a reminder to the learned tribunal for transmitting the record of MSC case number. List of that. Petition.
Okay. Problem. For hearing item number 10, Pathward Metro. Item 10.
Mr. PK petitioner is also not.
Next.
Lordship, timing, Lordship.
Item 11, Pathward Metro.
Lordship, on the earlier occasion, Lordship, we have filed our affidavit in reply in this matter, Lordship. Lordship, Similar matter is also listed on 25th, Lordship. So can this taken up on that day, Lordship, 25th? Yesterday, that matter was listed, Lordship. I asked for some time to file an additional affidavit. So in this matter also, I'll be filing that.
Because the parties are same.
No, parties are not the same, but the issues are same, Lordship. Here also, he is claiming UGC pay scale from the date of his initial appointment, Lordship.
Yesterday is which
Item,
matter?
item 15. It was fixed on
Who
25th.
appeared for the other side?
Lordship,
On
the teams. 25,
This is also
15.
UGC scale.
Lordship, Lordship, the effective date of giving the existing scale, whether it would be the date of regularization or the date of passing my MPhil examination.
Same, Lordship. Here also we have
And Lordship,
granted
similar benefit have been given to many candidates, Lordship. I have brought on those record, Lordship. I'm praying for a similar treatment, Lordship.
Okay. On 25th.
25th.
25th case.
Heard Mr. S.K. Das, learned counsel for the petitioner, and also heard Mr. D. Upamino, learned standing counsel for the higher education department. Mr. Upamino submits that he has already filed his affidavit in opposition, and he further submits that similar matter is pending before this court and listed on 25th of June 2025. And this matter also may be listed along with the WPC number. What is the number?
Lordship,
3820-2023.
yes, Lordship.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that justice shall list this matter along with WPC number
3820 of 2023.
on 25th. Okay.
23. 25th of June.
And
Lordship, matter will kindly for adjourn today, Lordship. My senior is not well, Lordship. MD Sodori,
Who is your senior?
MD Sodori, Lordship.
Pardon?
MD Sodori. MD Sodori.
No problem,
MD Sodori, this is of 2013.
Lordship,
matter.
any date. Tomorrow will be
Problem
available.
is always they are taking time for the case, my lord. It will be
Tomorrow fix.
tomorrow if not possible. It will be taken up on Tuesday.
When?
Tuesday. It's very.
No, no, ST has already notified the coming week as motion day. After vacation, you choose any date.
After vacation.
15. 15.
Mr. You have a good name.
N Borua, Lord.
15 July.
M. Borua, learned counsel, submits that Mrs. M.D. Chaudhary, learned conducting counsel, is unwell today and pressed for listing the matter immediately after reopening of the vacation. There is accordingly allowed. No, the pair having not been objected by Mr. Sharma, learned counsel for the respondent, stands allowed. Let's list the matter on
17 July.
17th.
17th problem.
15 July. Oh, 15.
7th problem. Sir.
Okay, 15.
15. 15. Okay.
Okay, we'll resume after 5 minutes.
Appellant is not there. On the last occasion he was present, he had submitted that he was newly engaged. It's an arbitration appeal.
Pending since 2014.
14. There is also a further difficulty I have seen, my lord. The documents are not part of the memo of appeal. We'll have to refer to the records or whatever relevant. I may place it because the issue is very simple, my lord. It was a supply contract. They were supposed to supply some materials which were used to be used for purification of water. The tender provided that once they supply the materials, we will test it in our laboratory. The quality was not up to the mark as specified in the tender. So we rejected that shipment. That is the case.
Anyway, in absence of the appellant, we cannot hear the matter. We'll fix it at however, after vacation.
After the vacation.
After vacation. None appears for the appellant call. However, Mr. N. Nekar, learned counsel for the respondent present. since the matter is of 2014, this is the list the matter of
31st July.
31st July.
Item 14. And if your lordship permits, I may prepare a synopsis of argument where relevant documents I'll annex. 14?
Yes. Sir. May please your lordship. This is for enhancement lordship. It's a very small judgment lordship. May I read the judgment first lordship?
Yes.
Page 8 lordship. I'm reading from page 9 lordship. This claim
First, you tell me what is the ground
yes lordship.
for enhancement?
On two grounds I have challenged lordship.
What are the grounds?
Yes, lordship. Without applying any multiplier, lordship, that award was granted, lordship, because
This is a death case or injury case?
this is a death case, lordship, and this is was a school teacher, government job. She is serving in a government school, lordship, and her age was 40 years, lordship. So without applying any multiplier, lordship, lump sum amount was granted, lordship.
How?
Nothing mentioned in the judgment, lordship. Only multiplier, lordship. Only three heads, lordship. Loss of dependency, funeral expenses, loss of love and eviction. But that's although it is proved that she is a government servant.
No, the question is to apply the multiplier.
Yes, lordship.
Whether there was any loss of income or not.
Yes, loss of income because she is a government servant, lordship. The claimant are dependents on her, lordship. That is, I have proved from my evidence, lordship.
So number one ground is no multiplier applied.
Yes, lordship.
Number two?
Number two is no future prospect.
No future prospect.
Yes, lordship. On these two ground, lordship, I have filed this appeal, lordship, for enhancement. Lordship can straightly go to page 12 also, judgment, lordship.
12.
Yes, lordship. That is the last paragraph, lordship. It is stated that the deceased was an assistant teacher of a local school with monthly salary drawn by her at rupees 27,260 only. The above fact is proved by PW2 Orun Tan by the exhibit 4. The age of the deceased was 40 years at the time of the accident. The claimant stated that about 1 lakh only was spent in the last rites of the deceased. It cannot be denied that the husband of the deceased was the driver of the offending car. This means that the father of the claimant is still alive. Therefore, the claimant are dependent of their father since no ground is shown that they are exclusively dependents of their mother. Accordingly, the compensation is assessed of loss of dependency, funeral expenses, loss of love and affection. And only 1,55,000 in case that case, that was awarded. Nothing mentioned. So on these two ground, I have challenged lordship because if her age is 40 years, lordship, so so multiplier should be 16, lordship.
Is 40 years.
Yes, lordship.
So according to you, multiplier as per Sola Burma's case?
Yes, lordship, that is 16, lordship.
16.
Yes.
Multiplier should be 16.
And as per Pono Sethi, lordship, regarding future prospect, lordship. While determining the income of an addition of 50% actual salary to the income of a deceased towards future prospect, where the deceased had a permanent job and below the age of 40 years should be made. In addition to 30% if the age of the deceased was between 40 to 50 years. Between 40 to 50 years, it is 30%. If it is she is a permanent job. In fact, in my evidence, I have proved that lordship, we are the dependent of the upon the deceased, lordship. PW1, lordship.
Okay. Yes, madam.
Lordship, what is submitting, actually, this calculation even I feel is not as per the judgment because the court has to give a reason why it came to 80,000 loss of dependency when the income was proved. Either they were not dependent, or if the court finds that they were dependent, it has to be calculated as per the salary because she was a teacher, lordship. So that part. And Lordship, about funeral and love and affection, Lordship, love and affection, Pranay Sethi itself says that there cannot be any love and affection. The court gave 50,000.
No, whether this amount awarded under this head,
Yes, Lordship.
is it there in the Pranay Sethi case?
No, Lordship, in Pranay Sethi 58, Pranay Sethi comes here.
No, this love and affection.
Yes, it was rejected, Lordship. In Pranay Sethi, it was said that there
Not
is
entitled.
Yes, there is no provision for in the MB Act for love and affection, so no amount is to be given. That there, Lordship.
It is not challenge by them.
No, I'm just.
Yes,
Lordship,
yes, I understand, I understand.
I'm just submitting
Yes,
what
yes.
is wrong or right in the
Yes.
judgment. Nothing more or less. I do not
So,
want that. What is
no,
genuine-
anyway, madam, you tell me, there is no dispute regarding her age and income.
Yes. No dispute about that. And Lordship, funeral expense, Lordship, court has given 25,000. It should have been 15,000, but then Lordship, loss of estate 15,000 is to be added. As per Pranay Sethi itself, Lordship. That was not given by the court. And Lordship, for our part, even if it is enhanced Lordship, Lordship will come to the, after the calculation, paragraph 9, Lordship, in the end. The opposite party number 1 is given liberty to recover the amount of compensation from the insured if desired. Lordship, so Lordship will give us that right. The owner has not challenged this portion, and they have in their appeal also not challenged this part of the judgment. So we have whatever enhancement or whatever judgment Lordship passed, we have a right to recover.
Recover.
Yes, that much only.
Recover from the owner of the vehicle.
Yes.
Owner has not contested the case.
No, not contested, and they have also in their memo of appeal not
Not
taken this
challenged
as
it.
not, and we have not challenged the.
No, they are not supposed to challenge it because their only object is to enhance the amount, get the enhanced amount.
Lordship, to be fair, the compensation granted, because if the court comes to the finding that they were not dependent, then fine, you reduce them. If the court finds that they are dependent and they get some compensation, so the calculation should be proper. It cannot be just 80,000 like that. That is my submission.
So how the tribunal has arrived at this 80,000 amount, it has not been explained in the judgment.
There is no explanation. It has to be reasoned, Lordship. The judgment has to be reasoned. There is no reason given. In the paragraph before that she has read, Lordship, the court came to the finding that 40 years of age and 27,600 income. But how the court came to the loss of dependency at 80,000, that is not.
Okay.
So that is, and we will get a recovery right.
Will pass the order.
Obligation. Go ahead.
Item 15.
May I please your lordship? Lordship, in this item, my senior name has not been reflected in the cause list. Therefore, we miss the cause list. A date may be fixed after vacation on 24th of.
Third, Mr.
A.K. Hannan, my lord.
A.K. Hannan, learned counsel for the appellant.
Yes, my lord.
And Mr. P.E.O. Loskor for the respondent. Mr. Hannan submits that in the cause list, the name of the conducting counsel, Mr.
M.J. Gadir, my lord.
M.J. Kadir, is not reflected. Then as such, he could not prepare to argue the matter today. No, he is not ready to argue the matter today and place for an adjournment. Here is accordingly allowed. Let's summarize the matter after immediately after reopening of the vacation.
On 24th, my lord.
Pardon?
On 24th July.
Let the rest be fixed.
Obligation.
Items 16. Items 19 and 20. 19 and 20.
19 lordship, I am for the petitioner in the CRP IO lordship. And in RSA, the respondent are the appellant. I am respondent there, lordship. My right title and confirmation was declared suit was dismissed, then first appellate court lordship reversed, right title of the plaintiff was declared. And thereafter, we filed execution petition, and in execution, one third party has filed an application that was rejected by the executing court. On being appealed, that was reversed. So I have challenged that order of the misappeal. And
No,
they have
in
preferred,
item number 19, you have challenged that order.
yes, lordship, passed by
But who
the
is the,
lordship. I informed him, lordship.
when?
Yesterday also I have informed him, lordship. The 2018 matter, lordship, and RSA is of 2000.
I am ready to hear the matter, but
Lordship, after vacation, your lordship can fix a date,
Okay.
lordship, then if they are not.
Art is also the learned counsel for the petitioner in item number 19, but none appears for the respondent on call. This is a list of matter immediately after reopening.
There is an
Appeal
interim
you
order,
take down.
lordship.
None appears for the appellant on call. However, Ms. Arsodore, learned counsel for the respondent present. List the matter immediately after reopening.
Lordship is for the respondent.
Lordship, this matter may come up some other day, Lordship. Just Sahoria will do the case and please leave.
Okay, after vacation.
Then lordship, a fixed date may be given as because Mr. Sahoria comes very often.
8th of August.
5 August, ne? 5 August. Lordship. And lordship, in CRPIO, there is an interim, lordship.
You are for respondent number 3. Yes. In CRP or in the appeal? CRP. Your good name, please?
Yes, yes.
Yes, thus. Learned counsel
Government
for the respondent number 3 in
GS,
CRP. Okay.
government advocate.
You are government advocate. You are government advocate.
Yes, lordship. 3 is state of Assam, lordship.
Okay.
Lordship, interim is there, that may be funny.
In CRP.
Yes, lordship.
Interim
CRP
order passed earlier. CRP.
lordship. Deeply applies.
21.
May it please the lordship. Lordship, in this case, the appellation filed on the ground that the vehicle did not have a policy of insurance, lordship. Insurance company had denied issuance of the policy, had given an evidence, lordship. In fact, what has happened, lordship, this policy was issued by the Ahmedabad office of the appellant insurance company. And an officer of this season, lordship, had produced the entire, lordship, this is a thick bunch of the entire premium register for 10 days prior to and after the alleged date of issuance of the cover note. This is this entire huge bunch of documents. They have said that all the entire premium register means, lordship, whenever a policy is issued, they have to enter the premium in a premium register. In a premium register. So if there is no entry in the premium register for this particular vehicle, that means no premium was paid. If no premium was paid, then insurance policy could not have been issued. They denied the policy. Insurance company had denied that no such policy was issued on receipt of confirmation from the Ahmedabad office. But lordship, that was rejected by the tribunal on the ground that lordship, I'll read out the ground, lordship. No. Para number 13 of the judgment, lordship. Address is a small amount, 1,10,600, but the policy was not there, lordship. Now it is to be determined who amongst the opposite parties will have to satisfy the award. The opposite party number 1, United India Insurance Company Limited, in order to disown disability, examine one DW named Sri Amitabh Modak, who is a senior assistant of the United Insurance Company Limited, Golpara branch, in order to prove that the offending vehicle was not insured with them. DW Sri Amitabh Modak, in his evidence, stated that Mr. J.K. Jain, Divisional Manager, United Insurance Company, Ahmedabad, informed that their Genesis system is not a software, computer software at that point of time, has not been showing any insurance policy for the cover note number showing dated nil of the vehicle under registration so and so is the engine number, chassis number, owned by Mr. Nazmul Haq. He in his evidence stated that no insurance policy was issued on the basis of the said cover note. But the DWC Amitabh Modak nowhere in his evidence denied the issuance of the cover note number so and so by the by the opposite number so and so. United Insurance Company. The insurer of the vehicle bearing register number so and so. He in his evidence only stated that no insurance policy was issued on the basis of the aforesaid cover note. As per provisions of section 147 MBA, the cover note issued against the vehicle has the same value and effect as an insurance policy issued insuring the vehicle. And some of the view that OP number 1 in a day who is to satisfy the award. Lordship, a technical difference was that the policy has been denied, cover note has not been denied. But what has the insurance company done is that they produced the entire premium register for 20 days. Lordship, Lordship, in this case, as per proposal, as per Lordship claim form, the policy was and as per claim form, Lordship, this cover note policy number that they have stated is for a period 29/3/10 to 28/3/11. So 29/3/10, 10 days before that and 10 days after that, the entire premium register has been sent by them, Lordship. This thick bunch of papers. Just to show that there is no premium against this chassis number, engine number, whatever is his name. After that, Lordship, just finding out only cover note policy has been denied, cover note has not been denied. I think it's taking a technical Lordship view of the it's a real that without it's a Lordship statutory provision, section 64 VB of the Insurance Act, that no policy can be issued without receipt of premium. That's a statutory requirement.
Which decision you were referring to?
Lordship.
What is the decision?
Not decision, I'm referring to a particular section of the Insurance Act. Insurance
Which
Act.
section? Which section?
Section 64 VB of the Insurance Act that says no policy can be issued by any insurer in India without receipt of premium. That is, premium has to be received, then only policy can be issued. That's the biggest sin any insurance company or any insurance official can commit. That he has someone has issued a policy without premium.
64 double B of which act?
Double B, lots of Insurance Act, VB. Section 64 VB. V and B, lots, VB. Yep, it's Insurance Act. What's in the Insurance Act? It was found that provision.
Okay. So the
Lordship.
cover note was not issued by.
Yes, Lordship. They said
company.
no premium means no cover note or policy. Policy cover note, Lordship, earlier it used to happen, people just to give immediate effect to that, they issue a cover note. But it is always followed by a policy. Policies with the all terms and conditions, cover note is a simple page document. They issued, okay, this vehicle is held covered. But that is always mandatorily followed by the policy, because it's a policy that governs the entire contract. It's a contract. Cover note is a document. Lordship, but any cover note or policy, whatever it is, Lordship, is the requirement is that the premium has to be paid first, then this cover note can be issued. Or policy. Nowadays, the practice of cover note has literally been abandoned kind of. So it's, because of practical difficulties. Now only policy is issued. Cover note is hardly issued. It's not that it's not, it's hardly issued, its policies are issued. But either policy or cover note, the primary requirement is the premium has to be deposited. Now, Lordship, once we had denied, if now both the parties were there, Lordship, owner and driver were also there before the tribunal. So they could have also produced the policy, Lordship, to prove us wrong.
Yes, so who is for the owner?
My lord, I am for the claimant, my lord. Just for number of one, my lord.
For the owner? No.
No, my lord.
Owner and driver, it was their duty to produce the document with them, Lordship. We have denied. So it should
Whether
have
any
gone
such
again.
document was exhibited before the tribunal?
By?
Any of the party?
No, Lordship. But our documents are this much. This is anti-evidence of the insurance company.
Overnote, my lord, my lord, as my lord, I have seen my lord elsewhere, my lord. Overnote is my lord, placed.
Is there?
Yes, my lord.
You show it.
Page my lord 79, my lord. File D.
उनके फाइल में कौन कौन सी?
17. 79, my lord. Let's go.
ये कर लो तो।
My lord, award is my lord at minimum, my lord. She's a poor person, my lord. She may not be capable, my lord. And once cover note is issued, my lord, so subsequent. my
No,
lord,
cover note, we are denying this cover note.
Cover note never denied, my lord. They denied policy.
Policy cover note.
But in fact, government also, my lord, say like that, my lord, since the my lord, insurance not denied the cover note, so they are liable.
But Lordship, the owner and driver, they were there. Owner was there. Why he could have come on affidavit saying that this is my cover note, I have to produce this. It may be a fake cover note also. Lordship.
Who has produced this
And
before the tribunal?
My lord, I don't know. Perhaps my lord, police submitted those reports, my lord.
Police?
Yes, my lord, perhaps. Investigation.
it's not that owner was expert here or something. Owner was there, Lordship.
Mr. Goswami, whether in this appeal, notice was served upon the respondents,
Lordship, we
driver
have,
and owner?
In this appeal, Lordship. Appeal, let's say, R1 to United, safe second, we have gone for paper publication, Lordship.
Paper publication.
Yes, sir, paper publication to list and paper delay conduct. Before. Paper publication on R1 and R3. R2 owner had filed local number, Lordship.
My lord, honor also the, my lord,
Owner had filed local number.
yes, you want that.
As per office note dated 5/8/19, R2 filed local number.
Correct.
We had taken steps on R1 and R3 subsequently by paper publication.
R2, sir.
Hmm.
You were referring to office note?
Yes, sir.
Who is that? Dated?
Lordship, my yes, Lordship.
I8 appear personal.
In the IA, Lordship, it was there in the IA.
It's not 5/8/19.
5/8/19, Lordship.
There are two IA in which IA?
1806.
1806, Lordship. Of 2018. 18,
2018.
18. Oh, it is delayed.
5/8/19.
SU Ahmed Punal.
আপনালোকৰ নেকি?
আমার নাম লেখা আছে, SU Ahmed Punal.
Cause list ত আহিছে।
Name has been shown in the cause list also. SU Ahmed for R2.
Do you know SU Ahmed? No. So let him complete contact with the council. We'll take it up in the second half
Second half.
today.
No, sir, tomorrow if possible also.
Tomorrow
Lordship, I have,
is a difficulty.
maybe
Let it be on other day.
tomorrow, Lordship. Just 1 minute additional.
Oh, lot of matters have been fixed.
Monday.
Shouldn't be Monday.
Yes. Oh. Okay, Lordship, up to second half.
Item 22.
Substitute हो गया ना? मैं विकास में कैसे? अधिवेशन में असले सब So this is an injury claim. Okay, what happened, Lordship? In this case, there's no certificate from any doctor or some power, right? To say that the injured person cannot appear before the court. His son appeared If that prayer would have been made, Lordship, the commission could have been issued to examine the year, Lordship, at year. Then that is, without, Lordship, even doctor was also not examined, Lordship. So this entire, the injured was kept away. Amount is also quite high by the time, Lordship, it's 11,60,000, that's my Lordship. And it was not done as per the settled positional law that we are following, Rajkumar versus Ajay Kumar, Lordship. Does that mean,
No,
Lordship?
that decision has been overruled now,
Which one, Lordship?
Rajkumar.
Rajkumar
Oh, that was not overruled.
That is there. But in that injured, my objection was that injured did not appear before the tribunal. His son kept appearing. There's no prayer before the tribunal that he cannot appear, he can be examined on commission. A commission could have been issued to examine at home also. But that was also not done. And injury was not so high, Your Lordship, that he could not have come to the hearing. This objection was taken, Lordship, in page 13 of the memo of appeal, Lordship.
Page number?
Page 13 memo, page 6 of the judgment, Lordship. Page 13 of the memo. Para 10, Lordship. In cross-examination, the CW1 has stated that he has filed an instant case on behalf of his father and that his father is still alive. He has, however, not submitted any document in testimony of the present physical condition of his father.
Paragraph number?
That's a paragraph 10, Lordship, of the judgment. Page 13 of the memo of appeal.
No, in the memo of appeal,
No, page 6 of the judgment and page 13 of the memo of appeal. Lordship. Internal papers. This objection regarding his not being present, that was asked, Lordship. In cross-examination, he, CW1, has stated that he filed an instant case on behalf of his father and that his father is still alive. He has, however, not submitted any document in testimony of the present physical condition of his father. He has, however, stated that his injured father can talk with difficulty.
then
No, that is not,
The
he has to
evidence
come,
would be
that is his statement, Lordship. Talking with difficulty, seeing a person injured, assessing his condition, we do not know what his year was. That was the objection taken. It is all, that also is not supported by medical document, Lordship. If that was the case, he could have said that this person cannot come to court or he cannot, he said that he cannot come. There is some difficulty in speaking. That cannot be a ground for not coming before the court. Or even that statement is not supported by medical document. No doctor's certificate has said he has something. It can be just to bide over the present year, Lordship. Give an excuse that why he cannot come. He can stop it. He further stated at the relevant time of his accident, his father was alone and his father was the registered owner of the motorcycle. He has said his motorcycle was examined by these are the year. But that particular part, Lordship, why he could not come to court, is not there, Lordship. He could have come to court and someone could have even spoken on his behalf before the tribunal. He has some difficulty, I'll communicate. The injuries do not suggest that he should have been. He was probably, it looks like he was being shielded, Lordship, from the cross-examination. That's the only ground, Lordship. That is the only ground.
Yes, Mr. Bhattacharya?
Yes, my lord, my learned friend has referred to the judgment paragraph 10. And what will come to the subsequent paragraph? It will come to the light that there was a hate-on collision between the, I'm reading the last paragraph now.
Kuntu.
Paragraph, no? Sub-paragraph.
ठीक है.
The investigator insurance company went to inquire from him about the accident and recorded his statement. The lordship got it. In the presence of his family member, he has denied the suggestion of the insurance company that he stated before the investigator the accident occurred head-on between the motorcycle and the car. Now it is important. He has further stated that he had shown his statement recorded by the investigator of the insurance company at 5 Exhibit A, dated 25/7/2001, and in the Exhibit A, he and his father had put signature. The visit white signature A1 and A2 respectively. That is the insurance company's presence. He has signed the statement. He has further stated the exhibit B is the statement given by his father. Thereby he has authorized his son, my lord. Because I have a decision on this of this court, my lord. Whenever somebody files a petition, if it is endorsed by the claimant, then it is, my lord, deemed to be. That is reported, my lord, in to the board.
No, sir, insurance company investigator goes in almost like a routine manner, go people, whether he lives there, he is there. So that it does not say that he cannot come to court. He has gone there, recorded his statement. They usually go and meet people to find out whether he lives there, what is his social status, whatever information they can. They are not trained in that.
But that is the separate
No,
issue, my lord.
that
As
cannot
my
take the
friend
place
said
of legal
that
aid.
the Father did not, father has signed the statement which is given by the insurance company. And whatever hypothesis, my lord, application claiming compensation referred without prior authority from the injured. The tribunal may treat the application as it is filed by the injured through a duly authorized person if subsequently the injured person appeared before the endorsed the action taken by the unauthorized person by claiming the compensation. 5 and 6, my lord. Paragraph 5 and 6. So here also, when the insurance went for the inquiry, my lord, he has endorsed it. He has endorsed it. The injured has endorsed.
I don't know if that will have any legal value also. Someone gives a statement to them.
Our high court decisions he cannot overrule. This is decision of the high court. In 1992, my lord. 5 and 6 paragraph. The lordship got it. Then, my lord, this is the insurance company went there, and on the basis of that, the MSCT court has passed the judgment. And secondly, my lord, if that point is there, I have clarified. And he has no other points, my lord. That's the end of the matter. Your lordship will decide on the basis of the decision matter. I have given the exhibit A and B, which has been endorsed by the father of the claimant. Because he is being injured, he is unable to come. The investigator went there. And investigator report he has signed, which is a part of the insurance company's document, and is produced before the court.
That is to say, man was still alive. That doesn't say that he cannot come to court. That is no legal.
That is not the issue. That is the judgment. He has
No, no,
clarified that.
Mr. Bhattacharya, why you did not examine him on commission?
My lord,
Why you did not examine the
because my lord, he
victim
is
on
not
commission?
able to speak, my lord.
Pardon?
He is not able to speak. The injury, the grievous injury, my lord. His got his everything broken here. He is unable to speak, my lord. That is the issue. If your lordship goes to the judgment, it will clear the asked by the MSC.
Who is, no, in this judgment you have referred to of this court, where it is dealt with, paragraph number?
Which my lord? 5
The
and 6.
judgment you have referred with,
5 and 6.
referred here,
Yeah, 5 and 6.
where?
The case number, my lord, Dr. Anandaram Borua versus another. Yeah. 5 and 6. Your lordship will take this might be the wrong one.
No, you have already furnished one copy to me.
Yes.
You come to relevant paragraph and show me. No.
Lordship, my paragraph 5 and 6. That may be wrong. I have given them paragraph 5 and 6. Just use. Every document. Gula, he will. It is there.
No documentary question.
No, I'm sure it was there. Anybody can file it there.
Anybody can. Had to come from. But at the time of, that doesn't say the entire claim petition.
So where is the medical document to show that the injured could not speak?
It's in the record. I think in the judgment, my lord, it is stated, my lord.
Where?
Let me go. Yes, in the first paragraph, my lord, in paragraph 10. He has however stated that his injured father can talk with very difficulty. In they have crossed, the cross they stated. Very difficult. But the law is that, my lord, anybody can accuse a person, and when he signed the statement,
No, there is no dispute about it.
that the insurance company went, the investigator went there, he got the signed the document. What else he wants, my lord?
No,
That is settled by our High Court also. my
Where?
lord. When the statement is given by the judgment hearing.
You
which
show me which part it is stated.
My lord, 5 and 6 paragraph, I think, my lord, repeatedly mentioned. I read, I have considered the submission made on behalf of the petitioner and the opposite party and have produced the impugned order and other matters. Technically, the impugned order does not suffer from any infirmity, but the provisions of law are not to be observed as a ritual. There lies the legislative intent as far as the jurisdiction principle beneath the word provisions of law. From the plain reading of the section 166 of the MB Act, it becomes apparent the legislature intendment regarding the entertaining an application claiming compensation by tribunal is very liberal. Section 4 of the section 166 empowers the tribunal to treat the report filed by the police officer regarding an accident as it were application under the provision of Motor Vehicle Act. What care is to be taken by the tribunal to see that no person other than the person entitled to compensation managed to get away with the compensation by being impersonation. In the case wherein the application is made by the person other than the person entitled to the compensation without being authorized, only courts for the learned tribunal may not be reject the application. The learned tribunal may treat the application as if preferred by the person entitled to compensation. If subsequent to the filing of such claim application, the real claimant appears before the tribunal and endorse the action taken by the authorized claim, compensation legislation intend to provide the mandate relief to the as per.
No, that is in respect of filing the application.
Yes, my lord, even the evidence also.
You
Evidence you can
show us, if the
Evidence cannot be.
investigator goes to the house of the injured
Yes.
and recorded his statement
Yes.
and court can accept it as evidence.
Yes.
What is that proposition?
My lord, this is their document, they have submitted, the investigator was there.
You tell me, can that statement be read as evidence?
Because when it was crossed, my lord, he has given that the documents exhibit A and B, that is a part of the record. That is exhibited.
No. I am asking you whether
My lord,
that statement can be read as a evidence.
my lord, when the document has been produced, that is before the court and it is
Maybe there may be
exhibited.
no, Mr. Bhattacharya, whether that can be read as a evidence.
My lord, yes, my lord, when it is produced before the court as an exhibit, why not, my lord?
It
is
can be
court-
read as a evidence.
Yes, exhibit A and B, it is record part of the record. How can it be denied, my lord? They have not raised any objection
That
to
can
that.
be read as a evidence of the injured person.
Yes, his statement and everything was there. What he is recorded there. They
You,
they have
okay,
never raised
okay.
an objection.
Mr. Bhattacharya, you so this court the provision that the statement recorded by the investigator could be read as a evidence. So we will fix it on Kobe.
Immediately after vacation.
Heard Mr. R. Goswami, learned counsel for the appellant, and also heard Mr. K. Bhattacharya, learned counsel for the respondent. Heard in part lays the matter after
Sir.
vacation.
17 July.
After vacation. So as to enable Mr. Bhattacharya, learned counsel for the respondent to show that the statement recorded by investigator, the statement of the victim, the statement of the injured recorded by the investigator and exhibited before the court during cross-examination can be read as a evidence as contemplated under the provision of CPC.
24.
My lord, this is appeal for enhancement. It's an injury case, my lord.
What are the grounds?
Grounds, my lord, first of all, illegality is made in the calculation, my lord, that I will directly show to your lordship at page 25, my lord, of the appeal memo, my lord. Inadvertent mistake has been done in the calculation part, my lord. Here, my lord. First, my lord, ground. Page 25, my lord, the bottom paragraph, my lord. Has your lordship got it, my lord?
Yes.
Considering the injury sustained by the claimant, obviously the claimant was attended by an attendance during the period of treatment. If we presume a loss of income of the attendant for 4 months, then it would comes to 12,000 per month. My lord, here, my lord, what is the court has done, my lord, while calculating the amount, my lord, court has only taken 12,000 without, actually it should be 12,000 into 4, my lord. Here it is written 12,000 per month for 4 months. But in the next page, my lord, while calculating the cost of attendance is written only 12,000, my lord. It should be 12,000 into 4, my lord, 48,000, my lord. Then, my lord, the rate of interest, my lord. First of all, the rate of interest is granted the very low rate of interest has been granted 6%, and that too, my lord, from the date inadvertently it is written from the date of cross-examination, my lord, in the order portion, my lord, 26, my lord. It should be from the date of filing of the claim petition, my lord. That's settled position, my lord. In my humble submission, rate of interest should be at least, my lord, 9%, my lord, because, my lord, in every case, my lord, nowadays, my lord, it's granted 9%, my lord. It's very low, my lord, 6%, and it is inadvertently, it has been given from the date of cross-examination, my lord. That cannot be, my lord, in my humble submission, my lord. Then, my lord,
you are demanding the rate of interest from the date of filing of the claim
petition, my lord.
When the claim petition was filed?
Claim petition was filed on, my lord, yes, my lord, 12 November 2010, my lord.
12 November 2010.
10, my lord.
And when you have filed the evidence?
Because, see, my lord, when the evidence has been filed, my lord, that. But there is a settled position, my lord, that the in rate of interest should be granted from the date of filing of the claim petition, my lord.
That is not the settled position.
My lord.
So you may file the application on 12/11/2010.
My lord.
But if you file your evidence in the year 2020, then you are not entitled.
But my lord,
claim the-
my lord, I have to see, just a minute, my lord, the evidence.
It has to be seen for whose fault the evidence could not be recorded in time.
Evidence is filed in the year of 2014, my lord.
2014.
14, my lord.
Who is responsible for the same?
My lord, the claimant is not responsible, it's a procedural delay, my lord, because
No.
we have not sought for any adjournment or something like that. After filing of the WS, my lord, then issues are framed, then my lord, the case has been fixed for evidence, my lord. Because they have never challenged that, my lord, we have caused a occurred in
Maybe,
delay,
but this aspect has to be looked into.
my lord.
This aspect has to be looked into.
My lord, but even from the date of my lord filing of evidence, my lord, it is seen that, my lord, there is no delay, my lord. It's only 2014, my lord, I have filed, my lord.
No, having filed the case in the year 2010. you
My lord,
file
that,
it
in
only
that case, my lord,
2014.
record has to be gone through, my lord, if we have taken adjournment or something, if it's not our fault, my lord,
So
then,
it
my lord,
that you have not taken any adjournment from the record.
my lord, that I have to check, my lord,
You
because,
check it.
my lord,
Then on what basis you are arguing the matter?
because, my lord, from the date of court examination, it cannot happen anywhere, my lord,
No.
my lord,
You go through the record.
my lord,
You show me that you have not taken any adjournment.
my lord.
Record. We will take it after some time,
My lord.
In the meantime, you go through the record.
My lord.
20, 25.
Correct, with the lordship. My lord, this is a second appeal, my lord, is against the concurrent findings, but issue is, my lord, both the courts below, my lord, applying the wrong application of law, my lord. Section Isbandary Act, my cases belong to section 13 of Isband Act, but both the courts below, my lord, decided the whole issue applying the section 15 of the Isband Act, my lord. And so this second appeal before this court, my lord, and this honorable court on 8 November 2023, my lord, the framed three substantial question of law, my lord. This is very simple, my lord. I will not take much time, in fact, in this matter. Here, my lord, the first question of law, my lord, whether the learned courts below have rightly decided the issue number 2, 4, and 5 in favor of the defendants by applying the provisions of section 15 of the Indian Easement Act by applying section 13 of the Estate Act, number 2, my lord. Whether both the courts below have misconceived the matter in hand and applied the wrong provision law, since it was not the case of easement by prescription under section 15 of the Easement Act, rather it is a case of easement of necessity under section 13. Whether finding the both the courts below suffer from perversity, since evidence from both the sides have been misconstrued as well as overlooked by the boards the court below while arriving at the respective finding. This is the three questions of law involved, my lord. And yeah, my lord, the appellant is the plaintiff. I purchased land from the defendant respondents, my lord. So accordingly, my lord, in the year of 2008, through registered share deed, my lord. Since 2008 to 2015, my lord, so peacefully I'm being allowed to use the said path, my lord. And this is the part I'm being allowed to use this only path to connect to the main road, my lord. Suddenly, my lord, in the year of 2015, there is a certain quarrel between the wives of both the parties, my lord. According thereafter, my lord, this fact has been admitted by the defendants. They blocked this road. That means 2008 to 15, I'm being allowed to use this path, my lord. And 2015 onwards, my lord, they blocked this land, and thereafter I prefer the title suit, my lord, and trial court decided the issue on section applying section 15. Then I preferred appeal again, my lord, section 15, my lord.
So you tell me what is the difference between section 15
Yes,
and
my lord.
13?
Yes, my lord. No, so kindly have a look at this man take, my lord. And this honorable courts, my lord, also decided on this point. I have brought, my lord, the two citations of this course and as well apex court, my lord. Section 13, my lord. My case. Here, lordship, the easement of necessity and quasi-easement, where one person transfers or bequeaths immovable property to another. Here, my lord, I will apply, my lord, ACE. This is the easement of necessity. A. If an easement in other immovable property of a transferor or the testator is necessary for enjoying the subject of the transfer or the bequeath, the transferee or legacy shall be entitled to such easement. Number C, my lord. If an easement in the subject of transfer or bequeath is necessary for enjoying other immovable property of the transferor or the testator, the transferor or the legal representatives of the testator shall be entitled to such easement. E, my lord. If an easement over the share of one of them is necessary for enjoying the share of another of them, the latter shall be entitled to such easement or. Now, my lord, the bottom line, my lord. The easements mentioned in the section clause A, C, and E are called easement of necessity. Here, my lord, that means what is to be section 13, where one person transfer or bequeaths immovable property to another. Admittedly, my lord, the immovable property, this is a land registered shall I have purchased from my owner, my lord. So it is the bounden duty of the owner to give me the part to use that part, my lord. Accordingly, this is the easement of necessity. This comes. Section 15 comes, my lord. When, my lord, I'm using someone else's land, my lord. Section 15. Acquisition by prescription, my lord. This is absolutely different thing. Where the access and use of light or air to for any building have been peacefully enjoyed therewith is an easement without interruption for the 20 years. This is the question. If I'm using without interruption for the last 20 years in someone else, accordingly, under this section 15, I'm entitled. But this is not my case. See, my lord, admittedly, I purchased land from my owner, defendant, my lord. It is a duty of when he sold the land to me, my lord, it is automatically, my lord, by using that path to the main road, it is automatically easement of necessity comes section 13 here. But both the courts, my lord, decided whole issue, my lord, despite their admission, yes, 2008 to 15.
You show me your WS?
Yes, my lord. My lord, in the evidence, my lord, in cross DW, this is important.
No.
WS, I will take,
You have taken such a plea in your written statement.
Lordship, he is the plaintiff.
Oh, he's a plaintiff.
I'm plaintiff,
Okay.
my lord.
Sorry.
I'm plaintiff, my lord.
Okay.
Lordship, in my plaintiff, kindly have a look, my lord, para 2, 5, and 8.
Para?
2. Before that, my lord, paragraph.
Number.
Page number 8, my lord.
Yes.
The plaintiff being the government employee of teacher by profession, he purchased a plot of land measuring 2 kathas of this purpose, residential place of work from defendant, executing registered child deed number so on 25/8/2008 at Morigaon sub-register office and took possession accordingly as delivered by the defendant. Number 2, my lord. But that there is no path coming to the main road intervened by the deep tank, and as such the defendant promised to give a path through his deep tank in case of plaintiff fill up the soil into the tank taking from the different places, and also if the pay of 40,000 to the defendant by the plaintiff. But that there was a good terms in the between both the plaintiff and the defendant. Transaction money of rupees 40,000 was paid to the defendant, and but this is not legible 2 lines here, my lord. Then, my lord, paragraph 8, 4. That a plaintiff has been living constructing residential house on the purchased land over 2 kathas, which he purchased the registered child deed and used for coming and going to the constructed path. The path was used by the defendant as well as plaintiff since 2008, but there was a sudden quarrel in between the wives of both the plaintiff and defendants in early of 2015, and since then both the defendants and his wife blocked the plaintiff and his family coming and going through that path, announcing that the plaintiff and his members of his family have no right to use the path. That, my lord, para 8, my lord, directly. That the plaintiff has got right to use the constructed path and as such feel this suit for easement right, declaring his own right for coming and going to his residence by himself as well as his member of his family, my lord. And accordingly, my lord, This title should have been filed for declaration of my inventory right, my lord, necessity of inventory right, my lord, for use of that part. And the WS lordship will find at page 14. Page 14, paragraph 6. Paragraph 6, my lord. The defendants partly admit and partly deny the averments of paragraph number 1 of the plaint. The defendant admits the plaintiff is a school teacher. Defendant admit that they purchased only 1 katha 10 lakhs of land for the purpose of residential place of work by executing a registered child deed. Yes, my lord. This paragraph we have at, yes,
Mr. Dekao,
my lord.
we will resume at 2 p.m.
Yes, my lord.
Item at 21 could not, he could not confirm the object. Not confirm.
I made contacted by lot, not confirmed.
It can come immediately after the vacation or if possible next week.
Prior to vacation, my lord, since there is urgency, my lord.
Well, it's not the next day, both of us will inform.
On Tuesday, my lord.
Heard Mr. Argusana, learned counsel for the appellant, that Mr.
Tuesday, my lord.
Your name,
M. Singh.
learned counsel for the respondent. Heard in court, list the matter on
Tuesday, my lord, next Tuesday.
after vacation.
That may be fixed, my lord.
Item 25, problem.
Wait, my lord. Item number 24, can it be taken up after vacation, my lord? Because next week it's not possible, my lord. 24. Have to bring some judgments also, my lord.
Okay. On the pair being made by Mr. Sundri, learned counsel for the appellant, versus the list the matter after vacation.
May I start, my lord? Lordship, the trial court findings at page 24, my lord. Before taking the appellate court, the trial court findings, I'll have to take lordship, kind attention. Page 24, my lord. And the issues at starts from page 27 onwards. Page 27, I can take your lordship directly, page 27 of the trial court's judgment. July.
Yes.
Issue number 2 and 3, basically, my lord. Whether the plaintiff has invented a right to use the part as described in the schedule of the plaint, whether the defendants have blocked the part mentioned in the schedule in the early part of 2015, my lord. Now, whether the plaintiff is entitled to decree as prayed for, to what reliefs and plaintiff is entitled to. How, my lord? Page 30, issue number 2 and 3 discussed by the trial court, paragraph 12. Both the issues are interlinked and so taken up together for discussion for the sake of convenience. In the present suit, it is an admitted fact that the defendants blocked the part mentioned in the schedule of the part in the early part of 2015. But in order to claim relief under inventory right, the plaintiff has to prove the continuous uninterrupted use of part for a period of 20 years. This is the question. And this has been widely discussed in the following paragraphs. The plaintiff in the instant suit has claimed his inventory right over a part measuring the 9 knoll, that is 120 feet, my lord, in the length and 1.5 knoll in the breadth, which connects his house with the main road on the ground. That the defendants gave the part to him for increase and egress on the payment of rupees 40,000 and on filling up of land over the part amounting rupees 20. The plaintiff in his plaint assert that the part was in use by him and the defendants since 2008. But in the early part of 2015, the defendants blocked the path, causing hindrance to the plaintiff in coming and going to the path. It is opposite at this point to mention herein that even though the Indian Easement Act is not applicable in the state of Assam, however, its applicable principle, the spirit is applicable in a case of Soencho Girin Chandra Soencho. Well, I skip this provision, my lord. Next, my lord, very next page, page 32, my lord. Now applying from here, my lord, first paragraph. Now applying the principle and spirit of the Easement Act read with the provision of section 25 of the Limitation Act, which deals with the acquisition of easement by prescription. Any claim for easement subsisting over a land except the land belong to the government would have to be weighed for the at least of 20 years before such right matured for the plaintiff. But a plain perusal of the plaint along with the evidence adduced by the plaintiff clearly discloses that the suit part has been used by the plaintiff only from the year 2008. and the cause of action arose on 9/7/2015. The plaintiff has not been able to show continuous uninterrupted use of the passage for about 20 years. As such, it cannot be said that the plaintiff has maintained a right over the suit Schedule LN as mentioned in the plaint. Moreover, it is also considered that the cross-examination of the PW1 that presently he is using a different path for the ingress and egress. At this point, I would like to throw light upon the submission of the learned counsel for the plaintiff, who submits that the plaintiff is entitled to easement right over the part as the same is a necessity for him. But the evidence of PW1 clearly depicts that there is another path available for him to ingress and egress. Hence, even though it is admitted that the defendants blocked the path as mentioned in the schedule of the plaint, but the plaintiff has completely failed to discharge the burden of proof upon him by showing continuous uninterrupted use of passage for 20 years in terms of the Section 15 of the Easement Act. According to issue number 2 decided in negative against the plaintiff, issue number 3 decided so and so. In the result of the suit, the plaintiff is dismissed on this ground. Then I prefer the appeal before the appellate court, my lord. At page 44, the appellate court's finding, my lord. Issue number 2 and 3 is concerned, my lord. Whether the plaintiff has easmented a right to use the path as described in the schedule of the plaint, whether the defendants have blocked the path mentioned in the schedule in the early part of 2015. Page 44 below. The impugn appellate court's findings below.
Page number
44.
Yes.
Paragraph 16, my lord. Whether the plaintiff has easmented a right to use the path as described in the schedule of the plaint, whether defendants had blocked the path mentioned in the schedule in the early part of 2015. The learned Munshi took up these two issues together for discussion and decision as both the issues are interrelated. The trial court has rightly and correctly held that plaintiff, in order to claim relief under easmented right, has to prove continuous and uninterrupted use of the path for a period of 20 years, and this has been widely discussed in the following paragraphs. The plaintiff in the suit has contended that he has easmented a right over a path measuring 9 nol in length and 1.5 nol in breadth, which connect his house with the main road on the ground that defendants gave the path to him for ingress and egress on payment of residential, and that he had filled up land over the path by spending an amount of residential. The plaintiff also contended that the path was in use by him and defendants since 2008, but in the early part of the 2015, defendants blocked the path, causing hindrance to him in the coming to and going to his house through the path. The learned trial court held that even though the Indian Easement Act not applicable in the state of Assam, however, the principle led spirit is applicable. The same case was discussed at Midok, that is Girindas and so Niranjan Borua, wherein the Honorable Guwahati High Court held that though the Indian Easement Act 82 is not in the force in Assam, there is no dispute at the bar that the principle underlying the provisions of the Act can be applied. Under Section 15 of the Act, where a right of way or any other easement has been peacefully and openly enjoyed by any person claiming, the title thereto as an easement, as of the right without uninterrupted and for the 20 years, the right to use such easement shall be absolute, and the period of 20 years shall be taken to be the period ending with the 2 years next before the institution of the suit, wherein the claim to which the period is contested. The learned Munshi also referred to Section 25 of the Limitation Act, which deals with the acquisition of easement by prescription, where any way or what water course or the use of any water or any other easement, whether affirmative or negative, has been peacefully and openly enjoyed by any person claiming title thereto as an easement and as yet of a right without interruption, and for the 20 years, the right to such access and use of the light.
Okay, all right.
My lord. And
both the court below held that.
Means Section
You have
15.
not been using that part for 20 years, and therefore you have no easement right.
Right.
Now you tell me how this section 13 is affected here?
Yes, my lord. In my support, my lord, in this honorable court is, my lord, two judgments clarified on this point regarding Section 13 and Section 15. My lord. Yes, 2006 supplementary GLT 498, my lord. This is the second appeal, my lord. Here also, the plaintiff filed a tackle suit regarding claiming the part, my lord, under Section 13, my lord. Trial court, my lord.
You come to the relevant paragraph.
Yes, my lord. Relevant paragraph, my lord. 9, 10, 11, 12.
Yes.
Yes. It would appear from the provision of section 13 of the Act quoted above in that the transferee of an immovable property would be entitled to the right of easement over other immovable property of the transferor if it is so necessary for the purpose of enjoying the immovable property transferred. In the instant case, there is no dispute the plaintiff had purchased the land from the original owner prior to the purchase of the defendant. The land purchased by the parties are different. However, the defendants after purchase they have been illegally obstructing the pathway for the plaintiff over a part of the land situated on the eastern boundary of their land, which according to the plaintiff, it is only pathway connecting their premises with the PW road. The Lana trial court dismissed the suit on the ground that the suit is not maintainable, being barred by law of limitation. While doing so, the Lana trial court fell in error in taking into account the provision of section 15 of the Easement Act. In the instant case, the factual metrics as depicted above call for review of the order in the light of provision of section 13. The Learned First Appellate Court has corrected this error committed by the Learned Trial Court. I have gone through the evidence on record as well as the reasons recorded by Learned First Appellate Court. The Learned First Appellate Court noticed that the dispute is in the respect of the pathway which belong to the original owner from whom the parties purchased their respective premises. The plaintiff in their evidence has maintained the stand consistently that there is no alternative path available to them as the outlet to the main road. In fact, this has been impliedly admitted by the defendants in the written statement. The plea is that the plaintiff had been using a different path since long time back for the approach to the PWD route, which runs through the land of the Centro. These persons are not the original owner of the land. The plaintiff cannot exercise any right of passage through their land. The evidence also do not disclose existence of any alternative path. Therefore, the plaintiff respondent cannot be denied of their right of passage from their residential premises to PW road. In my considered opinion, the plaintiff has been able to establish a case of easement by necessity as prescribed under Section 13 of the Easement Act, as because they have been able to establish that for the effective use of property, land purchased by them, the right of the easement through which the land described in so necessity, the court has to take pragmatic view of the fact and circumstances made available in the case. Judgment under appeals call for no interference by this court. Now, second lot, 1993 to JLR 228 is against the concurrent findings approached before this court, Milord. So the relevant paragraph 11 and 13, Milord. It is, however, true that the essence of easement is that it should be a right over the property belonging not to the owner, but to the someone else. The point of law which arises turns to the nature of the right claim and the nature of the evidence by which right is capable of the being supported. The right claim is actually an easement of necessity, but it seems lower appellate court failed to appreciate what easement of necessity is. Section 13 of Easement Act contemplates the easement which is claimed as easement of necessity can be claimed as the only possible mode of enjoyment of the right claim. In the case before me, the plaintiffs claim the suit path as the only way of them for egress and ingress. Without this pathway, which admittedly belong to the government, they cannot come out of the house. The Kabbalah exhibit shows that there was a pathway between the homestead of the plaintiff and the water tank of the bank of the tank, paragraph 13 below. It is found that the evidence on record is complete, but the learned Munshif did not arrive at any specific finding as to whether easement of necessity was specifically established. The learned appellate court also failed to appreciate what easement of necessity is. If an easement appears to have been acquired either expressly or by necessary application, it will amount to an easement of necessity under Section 13 of the Easement Act for the purpose of being liable to be extinguished under Section 14 of the Act. Hence, for the ends of justice, the matter must be remanded to the First Appellate Court, which is at present at the Court of District Drafts arrived to finding at the merits after considering the case in all aspects, my lord. Accordingly, my lord, this after concurrent finding in the Second Appellate Court demanded back to decide the issue on Section 13, my lord. So moreover, my lord, when the findings of the trial court, appellate court, the perversity, my lord, under this Section 13 of the Easement Right is concerned, Honorable Apex Court, one judgment, if your lordship permits me, under which circumstances this court can interfere, my lord. Please. Air 2006 Supreme Court 2234, my lord. Only the relevant paragraph I'll read.
Paragraph number?
My lord, 13, 15, 16, my lord, and 24, my lord. My lord, sorry, my lord, 24 and 28. 24 and 28. The principle relating to section 100 CPC relevant for
That is not required.
yes. Then my lord does this is our high court. This will suffice, my lord. And moreover, my lord, and the evidence of DW and PW is important here, my lord. For ready reference to your lordship, my lord, I have in the records also available, but I can supply in lordship. Yeah, record. Eight plus. My lord. And DW1, the original owner, my lord, during the trial he expired, my lord. Therefore, his wife is implicated and he given the evidence as DW2. So DW2 evidence, I'll have to draw your lordship and attention, DW2 evidence. So DW1 evidence is died, my lord, on the cross part. Wait. Oh, but that's only not there. Here, my lord, prosecution, evidence of prosecution only one, that is the plaintiff himself, my lord, and defendant DW1 and 2, one right, and 2 is the wife of the defendant number 1. The PW1 in chief, my lord, specifically I have taken in paragraph 1 and 2 in my chief, 1, 2, and 5, which I have read in my plain also, my lord. Same ground here have also taken, my lord. 1, 2, and 5. And 2, specifically, I have taken the play that is the only part to 1, 2, paragraph 1, 2, 5, my lord. And my cross, my lord.
Yes.
রাস্তার মাটিৰ স্বয়ঞ্চ কিসামতৰ ডাক নম্বৰ স্বয়ঞ্চ পাট্টা নম্বৰ স্বয়ঞ্চ আছিল। গোচৰৰ উল্লেখ কৰা বাটটোৰ মাটিখিনিৰ মূল্য পাট্টাদাৰ বিবাদী আছিল, বিবাদীৰ পৰা মই বেলেগেও মাটি কিনিছো। বেলেগে কিনা মাটিখিনি বিবাদীয়ে মোক ৰেজিষ্টাৰ কৰি দিছে, বাটৰ মাটিখিনি মোক ৰেজিষ্টাৰ কৰা নাই। This is the ইছমেণ্টেৰ ৰাইট, my lord. বাটটো থকা মাটিৰ ভাগটোত আগত নিখিল আৰু ভৌমিক আৰু বিবাদীৰ ভাগ, নিখিল আৰু ভৌমিকক মই আগতে পথাভুক্ত কৰা নাই। গোচৰীয়া পট্টাত মুঠ 19 জন মানুহৰ ভাগ আছে, এই গোচৰত 19 জন মানুহক ভুক্ত কৰা নাই। এইটো সত্য নহয় যে গোচৰীয়া মাটিৰ বাটটোত মই মাটি কোনোদিন পেলোৱা নাই, কিনি পোৱা নাই বা মাটি পেলাই ৰাস্তা বনাই পোৱা নাই। বৰ্তমান মই এই ৰাস্তাটি অহা যোৱা নাই, বিজু বেলেগ বাটেদি মই অহা যোৱা কৰিছো। Since they have blocked, so I have to use some another's land. Now, my lord, DW1, my lord, since he is died, my lord, so I got to read only the DW2. That is Dulu Bishwas, the wife of late Narayan Bishwas. Paragraph 3, my lord. That the part in question was not purchased by the plaintiff and no sale deed was executed by my deceased husband. The land where the plaintiff demanded a part is a periodic patta of 18%. Without the consent of the other co-pattadas, I along with other defendants cannot give the part to the plaintiff. Since the land on which the plaintiff claimed a part belonging to 18 persons and those persons are not made party to the suit is liable to be dismissed for the non-gender parties, it is already answered by both the court in my favor, my lord. The plaintiff has a convenient plate part in other direction of this land. Copy it, sorry. 6, my lord. That the original documents of the Jamabandi, the revenue receipt, the PP number relating to this case are submitted in the title suit case number 10 of 2006, which is pending in the Honorable Munchief number 1. This is the suit, my lord, regarding 10 lasses of land dispossessed by me by the defendant side, according to trial Munchief quoted during pendency of the second appeal, my lord, that's been passed in my favor, my lord. Next, my lord, the cross. DW2. I know the plaintiff Sitanath Mandal, who has purchased land from my husband. The plaintiff Sitanath Mandal has also kept roads, cement, and other buildings material for construction in the said purchased land, and the plinth has been constructed. I cannot say how the materials are brought. We also reside in the same plot of land. When the plaintiff purchased the land, there was no hole along with the passage through which we can come and go, and no vehicle could pass through the said passage. But now I am widening the passage. It is a fact that I have blocked the passage through which the plaintiff come and go, and for which the plaintiff could not take the building materials and his construction is half done. I have been residing in the said plot of land since 30-40 years. The passage through which we come and go belong to other people. I have been using the said passage since 30-40 years, and 40 years from now, one Prafulla Rai had obstructed us from using the said passage, but after his death, no any obstruction was made. It is not a fact that I have allowed the plaintiff to use the said passage. It is a fact that I have allowed the plaintiff to only to take his building materials for the said passage. It is a fact that the plaintiff has brought 40 tracts of land through the said passage.
Mr. Tekta,
My lord.
where is the contention that except that road, there is no other road leading to the land belonging to you?
My lord, in my plaint as well as in my evidence, I have taken this plea, my lord, and they have not denied that we have purchased this land, my lord.
In the plaint, you have taken that plea.
My lord.
In the plaint.
Yes, in the plaint, my lord.
Which part?
Paragraph 2. Paragraph 1 is the purchase, paragraph 2 is the only part. And the obstruction at paragraph 5. And very purpose of the filing of the title suit is for using of that part only. Since I have purchased from the defendants, so admittedly, my lord, it is my right to use this part, my lord. It is not that some other lands I'm using. There's 615 demands, my lord. That for the I have to.
So in paragraph number 2 of your plaint, you have taken such plea.
Yes, my lord.
And also in
In
evidence.
my evidence examination chief, paragraph 2. Paragraph 1 regarding the registered deed through which I purchased the land, and paragraph 2 is the main.
Okay. Yes, madam.
In this case, Lordship, the paragraph 2, which he is saying that they have already taken the Lordship, kindly see. Paragraph 2, it is mentioned that, but there is no path coming to the main road intervened by a deep tank. And as such, the defendant promised to give a path through his deep tank in case plaintiff build up into the tank, taking from different places, and also it paid rupees 40,000 to the defendant by the plaintiff. But that there was good terms in between both the plaintiff and defendant. Transaction of money of 40,000 was paid to the defendant. Thereafter, it cannot be written. That accordingly, the plaintiff paid rupees 40,000 to the defendant and filled up the tank for the path with 30 43 dumper of soil, ₹700 per dumper, costing total ₹30,000, and completed the work of the path using the path without any hindrance from anybody else till 9/7/2015. So Lordship, he purchased in the year 2008, and Lordship, till 2015 he used that part. So the easement of prescription will not come, and in his pleading in prayer portion, he prays only for easementary right, Lordship. The suit itself written as a title suit, page 8, Lordship. A title suit under section 9 of the CPC praying for declaration of the plaintiff's easement right over a small path through the land of the defendant number 1, who received ₹40,000 from the plaintiff for the land of the said path. So as per Lordship Easement Act, easement of necessity is if there is no other alternative or no other alternative to use by the plaintiff, then only he can be allowed to use that path. In our case, Lordship, we allowed him to use that path for a period, Lordship. Thereafter, there is an alternative path. He is already using that path, Lordship. But
There is
this-
alternative path.
Yes, Lordship, in the evidence portion, plaintiff already admitted. But Lordship, my learned friend has read only the top of the evidence part.
Which part?
PW1, Lordship. Cross part. Last two paragraphs, Lordship. এইটো সত্য নহয় যে ভিতৰীয় মাটিৰ বাটটোত মই মাটি কোনোদিন পেলোৱা নাই, কিনি পোৱা নাই, মাটি পেলাই ৰাস্তা বনাই লোৱা নাই। Thereafter, Lordship, 2 lands. বৰ্তমান মই এই বাটেদি অহা যোৱা নাই, বেলেগ বাটেদি মই অহা যোৱা কৰো। So he admitted, Lordship, there is an alternative path, Lordship. So question of easement of necessity will not come, Lordship. And my learned friend is saying that the easement of necessity was not taken into consideration by both the courts below. But Lordship, the trial court judgment itself discussed about the easement of prescription and easement of necessity. Both the easements were discussed by the trial court. My learned friend has already read out the portion that 20 years not completed, then there are page 32. Moreover, it is also considered in cross-examination of PW1 that presently he is using a different path for ingress and egress. At this point, I would like to throw light upon the submission of the learned counsel for the plaintiff, who submitted that the plaintiff is entitled to easementary right over the path, as the same is a necessity for him. So easement of necessity was taken into consideration by the trial court. But the evidence of PW1 clearly depicts that there is other path available to him for ingress and egress. When there is no pleading as regards to easement of necessity in the plain, even though Lordship trial court considered that evidence of necessity of the submission of the learned English counsel for the plaintiff, and thereafter decided it on the basis of the oral admission of the plaintiff PW1. So there is no perversity. It's a question of fact, Lordship. Already it is proved by both the courts below. First appellate court also, while deciding issue number 2 and 3, decided this point. 20 years, it is admitted fact, Lordship. He purchased in the year 2008, and till 2015 he used that path, Lordship. And thereafter, due to some altercation, Lordship, between both the parties, we denied to access into through that passage, Lordship. For some time, we allowed him for construction of his building, Lordship. Thereafter, due to some altercation between both the parties, we blocked that. That is admitted, Lordship. It is our personal way, Lordship. There is alternative.
Okay.
You provide.
Mr. Data, now you show me where is your case.
First of all, my lord, admittedly,
Admittedly, you have been using alternative path.
my lord, that is, I'll clear on this point, my lord. Till 2000, after purchasing of the land, as per section 13, my lord, if your lordship permits me, I could read again, my lord, section 13. Easement. Section 13 comes whence, my lord? Where one person transfers or bequeaths immovable property to other. That means defendant transfers the immovable property to me, my lord. Accordingly, when I purchased land from the defendant, my lord, they are allowed me to, after purchasing of the land since 2008 to 2015, due to certain quarrel, they blocked. Thereafter, my lord, to manage things, my lord, for temporarily, my lord, I approached before the trial court as my inventory right, my lord, to get it. This is since I have purchased, I am right to get this part, to use the part, my lord. Since for the 8 years, they have allowed me use the part. So there is a quarrel between the two wives and they blocked the plot, my lord. For my inconvenience, my lord, if I am for temporary period, I am using some other land, that doesn't mean that that they will permanently allow me to use that part. Since this is my permanent right, I have purchased this through registered child, they are not denying this right, then they are bound in duty to give me the part, to use the part to go to the main road, my lord. If since 2008 to 2015, I've been allowed. They're not denying that fact, my lord.
Mr. Tekka, you see, you have referred one decision of this court in Monwar Ali
My lord.
versus Sopat Jason Bewa.
My lord.
In that case, the court has held that the party, the appellant,
My lord.
has an inventory right under section 13.
Lord.
There is no yes, sir, that is the only pathway connecting their premises with the PWD road.
In all the judgment cited by my learned friend while he was submitting lordship, I have heard that there is a finding that there is no other alternative path, lordship.
That's right.
In both the judgments, lordship, in 2006 and 1993, the DLT
So these judgments goes
My lord,
against you.
in judgment, my lord, my lord, in a Monwara Ali case, my lord, paragraph 4, my lord, there what in the purchased. That means plenty purchased the land defendant. Here also I am purchased the land from defendant, my lord. Whether my learned friends is also very much aware that I am purchasing land from the defendants, my lord.
No, there is no dispute.
And
That is
alternative,
disputed.
my lord, while they have blocked that road, I have to manage some for temporary period to using some other land. That doesn't mean that they will allow me to continue. Since this is my right to get, since I am getting this right from their, my lord, I purchased land from them. So it is duty of the defendant, the owner, to give me a part to why they are saying that I'm using some different person's land. Since 2008 to 15, they have allowed me to use the part. So they have blocked, and after they are saying that yes, at present for temporary arrangement, I'm using some part. That means that there is some alternative arrangement. Why the other person will allow me to continue, my lord? Therefore, I ventilate my grievance, my lord. I approach before the civil court, my lord, regarding by claiming my right. It is not that I'm the outsiders, my lord. I'm purchased the land, my lord. It's the duty in 2000. Therefore, 2008 to 15, I'm been allowed to use the part. Just because of one quarrel, they blocked the part, my lord. And when all the citations I'm relating, my lord, this is the purchased, my lord. In paragraph 4 also, the Monwara, sorry, my lord, that, my lord, and Monwara Ali, that with the plentiful purchased land, they accordingly they have right to get.
That's all right. But there is alternative road here.
Alternative roads are different for temporary arrangement. I'm using this is not, since, my lord, they are owner of my land, my lord, and I'm getting this land for registered child, my lord. So accordingly, under section 13, this is my right to get the part, my lord. For alternative arrangement, my lord, since they have blocked, from which road I will use? So requesting some other person's, my lord, kindly, since I'm going to file title till and they get a decree, I may be allowed to use the part, my lord. Why they are saying that this is permanent
Mr.
alternative
Dekka,
part?
can it be said that having used an alternative road, you have satisfied the requirement of section 13?
Absolutely, my lord, section 13, this is the since I'm participant, accordingly, I got the right, it's a section, section 13, my lord, this is my necessity, my lord. So I purchased this land, you have to give me to part that. This is my right, my lord. Why? I am purchasing land from them, and they are saying that you are enjoying, you use some other's land for increase in egress, my lord. What kind of logic is this, my lord? And defendant, DWT herself admitted, and she has blocked this road. We have been allowed to 2008 to 15. Sudden quarrel happened, my lord. Had it been not quarrel happened, until that I'm using that part, my lord. Just because of one quarrel, they blocked my part, my lord. And I have purchased the land. They have. It is not that some from sky I got this land. When I registered child did, I got this right, my lord. So it is the duty to give me a part, my lord.
You do one thing. You produce on a sketch map before this court on next date. by which road you are entering to your land and going out of that land? We'll see there.
My lord, my learned friend, he is very much aware of this. Kindly apni koi diyo, kuntu line discuss koi diyo.
No.
Yo, kuntu case
Mr.
koi diyo.
Deka,
My lord.
you produce the sketch map of the concerned place. Showing your land, the land of your vendor, and the road which you are using, and earlier, the road earlier you had used.
Yes, my lord.
That sketch map.
Sketch.
There may be required.
My lord, my learned friend.
Pardon?
They may be required to some application.
Yes, they will file an additional affidavit.
Lord.
Yes, my lord, we will do that.
And Lordship, the page which was cited by both the courts below in RSA number 203.
Yes, sir, that is there.
Lordship, I have gone through that, Lordship. In that case also, Lordship, there was no evidence by the DW for claiming his inventory right. And very recently, 2024 Supreme Court decision, Lordship, that is in Manish Mahendra Gala case. 2024 6 SCC 130. No. Para 32, your Lordship will find the regarding inventory right. This is also, Lordship, first time I am going through a inventory of necessity case. This para 32, the inventory right by necessity could be acquired only in accordance with section 13 of the Act, which provides that such inventory right would arise if it is necessary for enjoying the dominant heritage. In the instant case, findings have been returned not only by the appellate court but even by the trial court that there is an alternative way to access the dominant heritage which may be a little far away or longer, which demolishes the easement of necessity. There is no justification to go into those findings of fact returned by the court below. So, Lordship, it's a finding of fact, Lordship. There is no perversity in regard to that. So, if there is no perversity, Lordship, under section 100, Lordship,
Definitely, we will see. What Mr. Deka, what I counsel for the photo. Learned counsel for the response. This is the method.
My
For
lord.
further hearing.
My lord.
This is a list of method as further. Then in the method, Mr. Deka shall bring and report the sketch map of the concern plus concern of the schedule let the path by way of it.
By an additional affidavit. Deep Lovelace.
Item fixed at 2 p.m. Number 10.
Yeah, please. I'll take marks and. They already lots of have been caught. Here, my only thing is that petitioner. Here, before the screening, constituted as per the judgment of this honorable court in the year 2010. That means she relinquished her right, his right. And admitted as himself as a illegally appointed teacher. And accordingly, the state authority has prepared the list of illegal irregular teachers who have accommodated as a tutor in the year 2021. And further, petitioner has joined in the year 2021. Thereafter, since then he is receiving his salaries, and only in the year 2023, this writ petition was amended. Once petitioner has appeared in the illegal irregular screening committee, petitioner has relinquished his right. As per in earlier cabinet decision of 2005, petitioner should have pursued this writ petition which he has approached in the year 2010. But after appearing in the screening committee, petitioner himself relinquished his right and admitted himself as an illegally and irregular teacher, and accordingly he has appeared. And further, the judgment which relied by my learned friend
That is reported in AIR 1986, Supreme Court 1571. Central Inland Water Transport Corporation Limited and others versus Rosanath Ganguly. And my lord. 2002, all LJ 2829, that is my lord, Hindustan Times and others versus State of UP and others, my lord. These facts and circumstances of this case are different from this present case, my lord. These are not similar, and the facts and circumstances as difference from the present case. That is why this cannot be, my lord, same facts and grounds, my lord, cannot be considered in the light of these judgments, my lord. And we have filed our affidavit here, my lord. We have specifically admitted that petitioner appeared in the screening committee. And after accepting his appointment of order, my lord, as a tutor, he has relinquished his right, my lord. Here, there is a condition, my lord. He cannot claim the past benefit, my lord. That's all, my lord. Regarding petitioner number 2, he has already retired from service, my lord.
So according to you, the petitioner forfeited his
Yes.
right by appearing before the
Screening committee, my lord.
screening committee.
My lord, constituted as per order of this honorable court, my lord. And thereafter, my lord, advertisement was issued, my lord, in the year 2011, 2012, my lord. That is stated in our affidavit, page 85, my lord.
Paragraph number?
Para 7, my lord. Oh, sorry, my lord. Para 8.
Okay. And the decision cited by her are
Not
distinguishable.
similar to this
The
facts
present,
and circumstances of this case,
fact-
my lord.
Okay. Yes, any reply?
Lordship, I would like to reiterate what I have submitted on the last occasion, Lordship, in regard to the relinquishment of petitioner's right, because it has been already pleaded under the paragraph number 12B in the amended writ petition. This is where I was trying to make out a case, Lordship, regarding the bargaining power of the petitioner, wherein after logging over, and Lordship may kindly note that it was never a case for regularization, Lordship. It was for readjustment of the already regularized post.
Okay. Part means either learning for the petitioner or the for the Sunday council for the respondent name, elementary education department argument.
Let's
Item fixed at 2 p.m. Item number 30 for hearing.
3031. What are 31? In the suit, we are the defendant, and the suit was for partition filed by the plaintiff. Plaintiff and defendants are the step brothers. Here, main contention in the suit is that a land measuring 4 bigha, 1 katha, 1 lecha, which is divided by two ducts, that is duct number 275 and 274, is the ancestral property left behind by the predecessor in interest of plaintiff and the defendants. And that's why they prayed for a decree to partition the land, which as per their calculation, 1 bigha and so to be falls in the share of the plaintiff, the defendant number 1, 2, 5 and 6, 7 and 8. So the main crux of the matter, which was decided by the learned trial court as to whether the total land measuring 4 bigha, 1 katha, 1 lecha is the ancestral property of the plaintiff and the defendant is yes or no. We contended before the learned trial court that out of the 4 bigha, 1 katha, 1 lechas of land, a land measuring 3 katha, 18 lechas of land was purchased by Mr. Moeshwar Gogoi, that is the predecessor in interest of different number 1 to 5 independently. So this is not the ancestral property of the predecessor in interest of the plaintiff and the defendant. So the entire land cannot be partitioned as sought for by the plaintiff. The learned trial court dismissed the suit. In this suit, we filed a counterclaim. The counterclaim was for declaration of right title interest over the land. Our counterclaim was decreed. In the appeal filed by the plaintiff, the appeal was allowed, holding that the plaintiffs are entitled to get the share in the property. So far as counterclaim is concerned, in the appeal, I could see that there is no finding particularly on the counterclaim. And
In the appeal?
In the first appeal. The appellate judgment says the appeal has been preferred under Order 41 Rule 1, 151 CPC against judgment and dictated 2010, 28, 10, 2021 passed by the learned Munshi number so-and-so in title suit number 66 of 2012. Dismissed the suit and came up for hearing. So far as finding on the counterclaim is concerned, there is no independent finding given by the learned first appellate court.
Whether any point for determination was formulated?
No, my lord.
By the appellate court?
No, my lord. And that's why this is one of the substantial questions of law.
In fact, there are two connected cases. In the other case, that I am the plaintiff, your lordship, I am for the another defendant, your lordship. The substantial question of law was specifically framed in this regard, your lordship. In my case, in his case also, I suppose there is a substantial question of law, that there was no point of determination.
But there is a decision of Supreme Court that even though the appellate court did not frame any substantial, no, it did not frame any point for determination.
Yes, sir.
formulate any point for determination, but if there is any discussion on the issues, then there is no requirement for formulation of any point for determination.
There is a recent decision in that effect, Your Lordship. However, there are other decisions as well. Mallaru Malappa, Your Lordship, knows, Your Lordship. Because in this case, all the issues are again taken up by the appellate court one by one. No doubt, Your Lordship. All the issues are again rediscussed and reappreciated. by the
Then the requirement is fulfilled.
Lordship, however, in an appeal, as to how it is a trial and an appeal. There is a subtle distinction between the trial and an appeal. In a trial, the court will appreciate the findings and do everything, Your Lordship. In an appeal, first of all, the court will have to appreciate how that finding is bad and then go to appreciate all the issues. Even as per the recent decision, if it is a specific point of determination is not named, however, there has to be a finding as to how that previous issues, the determination of the previous issues was bad. As such, all the issues are again rediscussed, Your Lordship. But in this case, all the issues are rediscussed as if a fresh trial on the same issues are taking place.
So the decision?
Lordship, just I have to take the printout, Your Lordship.
Pardon?
My item is the next item. I am just asking somebody to take that. Let him conclude, Your Lordship.
And there are other grounds too in the appeal that the Exhibit 6 document, which shows that I have purchased the land independently, a land measuring 3 kathas, 18 lechas, out of the total land measuring 4 biga, 1 katha, 1 lecha. There is some absurd finding been arrived into by the learned first appellate court, in as much as the findings recorded in favor of the defendant was set aside for without appreciating the Exhibit 6 document. If I may take your lordship for a moment to the issue number 6 decided by the learned trial court at page 57.
Yes.
The issue is whether the plaintiff has right, title, and interest in the 1/3 share of the total suit length. From the averment of the pleadings of both sides, the admitted position is that the plaintiffs and defendants are the step brothers, and the father of defendant number 1 to 5, namely Moheshwar Gogoi, was the son of late Meuka Gogoi. The plaintiff number 3, in order to prove their case, has brought on record his testimony as PW1. PW1 Praveen Kumar Borua has submitted and supported the contentions in the plaint. In his cross-examination, he admitted that they had mutated their name in the suit line in 2002. He also stated that he had an old copy of Jamabandi, but he did not bring it to the court. He further stated that PW1 had not submitted any document regarding sales instrument by Dhaneshwar Borua regarding the suit land. PW1 has himself admitted that the suit land was enjoyed and possessed by the Moheshwar Borua and Pyari Mohan Borua since 1952. Moheshwar Borua and Pyari Mohan Borua are the defendants. He also stated that his father was expired in the year 1995. From 1952 till the death of his father, plaintiffs and his deceased father had not taken any steps for the suit land. PW1 has admitted in his evidence that Dhaneshwar Borua was not the father of Moheshwar Gogoi. The real father of Moheshwar Gogoi was Meuka Gogoi. PW2 has stated in his evidence that the suit land was possessed by Dharmeshwar Borua. He had 3 sons, namely Moheshwar Gogoi, Ramakanta Borua, and Pyari Mohan Borua, which was contradicted by PW1. They had inherited their father's property. PW2 supported the contentions of the plaintiff. In his cross-examination, PW2 submitted that he did not know who had purchased the suit land. He admitted that Ramakanta Borua had left the suit land after 1 year of Ramakanta Borua's marriage. Ramakanta Borua is the plaintiff, which is approximately 60 years ago. He further stated that at the time of Ramakanta Borua's marriage, Pyari Mohan Borua and Ramakanta Borua were living as a joint family. After leaving of Ramakanta Borua, Pyari Mohan Borua was living in the suit land, and after the death of Pyari Mohan Borua, his family were living there. He further stated there was an oral partition between Pyari Mohan Borua and Ramakanta Borua. Therefore, defendant number 6, 7, 8 had enjoyed and possessed this suit land. PW3 Bhupen Mohanto Latmondala Charidwar Revenue Circle in his evidence stated that in Exhibit 5 there were 7 pattadars. The serial number 1 name is Binod Borua. Serial number 2 and 3 are Dighola Gogoi. Dighola Gogoi is the nickname of Ramakanta Borua. And Piari Mohan Borua. Serial number 4, 5 and 6 are Rupeshwar Gogoi, Uttam Gogoi and Tonkeshwar Gogoi respectively. The total land measuring under Dag number 275 and Patta number 73 is 6 bighas 1 lecha. The portion of the land had not mentioned there. The 7 names were inserted at the time of settlement. On 1/3/2002, the names of the plaintiffs were inserted. DW2 also stated that long back, plaintiff's predecessor, late Ramakanta Borua, had gave up his share of the suit land in favor of his younger brother, Priyari Mohan Borua. DW3 had also stated in his evidence that Ramakanta Borua had left the suit land and relinquished his share and gave to Pyari Mohan Borua, which was supported by PW2. From the foregoing discussion of evidence and the reasons, it transpires that plaintiff's father Ramakanta Borua had purchased the suit land jointly, which is admitted by defendants, and approximately 60 years ago, Ramakanta Borua had gave up his share to his younger brother, late Pyari Mohan Borua. Apparently, from the pleadings itself as well as the evidence rendered, it is clear that the plaintiffs do not have possession over the suit land. The plaintiffs have share land on the suit land, but plaintiff's side has failed to prove that the suit land was owned and possessed by late Dhaneshwar Borua. Plaintiffs also failed to prove that the sons of late Dhaneshwar Borua, namely Moheshwar Gogoi, Ramakanta Borua and Pyari Mohan Borua, had agreed equally to divide the suit land as 1/3 share of the total A suit land as PW1. Himself admitted in his cross-examination that late Moheshwar Gogoi was the son of Mehuka Gogoi. DW5 in his evidence stated that Exhibit 5 is the Jamabandi book of 1930 of Revenue Village and Moja Goroimari. Exhibit F1 is the Jamabandi of Patta number 92. There was only one Dag, number 258 in the said Patta. In the said Dag, there were total 6 bighas 8 lechas land. Moheshwar Gogoi, son of Mehuka, was the original Pattadar at serial number 8 as per the note dated 2841 of the said Jamabandi. Land measuring 3 katas 18 lechas was mutated in the name of Moheshwar Gogoi, that is the defendant, by way of purchase from Ghono and Norendra. Exhibit 6 is the Chitha book of Jamabandi, Dag number 274, identified by PW3. Exhibit G1 is the Chitha of Dag number 258 Revenue Village, Nij Goroimari. The Dag number 258 was converted to Dag number 275. Total land of the said Dag was 6 bighas, 1 lecha. Exhibit H is the draft Jamabandi of village Nij Goroimari. Exhibit H1 is the draft PP number 79. As per said draft Jamabandi, the old Dag number 258 converted into Dag number 275. DW5 also stated in his evidence that another note dated 13/11/46 in the Jamabandi reflects that as per order 17/7/1946 of the said Jamabandi, name of Moheshwar Gogoi, Dighola, Pyari and Soru Lora has been mutated by way of purchase and possession in place of Ghono and Norendra. Therefore, it was clearly established that plaintiff's late father had purchased the land in the same Dag. From the evidence of the plaintiffs and defendant as discussed above, I find the evidence of defendants more probable. In view of the evidence as discussed, I am of the considered opinion that the preponderance lies in favor of the defendant. Therefore, the plea of the defendant seemed to be more probable and believable. Hence, this issue is decided in negative against to the plaintiff. There is a clear finding relying on Exhibit 6 document and Exhibit F that out of the total land as mentioned in the plain, and land measuring 3 kathas 18 lechas was purchased by Moheshwar Gogoi, that is the defendant's predecessor interest of the defendant, independently. If it is so, then the partition of the land purchased independently by the predecessor in interest of the defendant cannot be included in the total land to be partitioned. Well, this issue was reversed by the learned First Appellate Court in the manner your honor will find at page 105. To cut it short, if I may take your lordship to page 106, four lines from bottom, fourth lines. In the exhibit F, there found only one duct being 258, total land being 6 bigha and 8 lecha. In the said patta, name of late Moheshwar Gogoi was mentioned as original pattadar having his land about 3 katha and 18 lecha by purchase from one Ghano and Narendra. The learned court also perused exhibit 6, which was the Chitha book of Jamabandi Dag number 274 and was identified by PW3. She also perused the Chitha of Dag number 258, which was subsequently converted into Dag number 275. In para number 46 of the judgment, it is found that the learned trial court took the view of a note dated 13/11/1946 inserted in the Jamabandi. It is found therein in the note dated 17/7/1946 that names of Moheshwar Gogoi, Dighola, Ramakanto, Piari Mohan and Saru Lora has been mutated by way of purchase and possession in place of Ghano and Narendra. In view of that, the learned trial court affirmed that the father of the plaintiff purchased the land over the same duct. Therefore, where the learned trial court itself affirmed the right of the plaintiff on scrutiny, the evidence on record determining the issue against the plaintiff is indeed wrong and need to interpret. The finding of the learned trial court was that on the basis of the Exhibit 5 document and Exhibit 6 document, it was held by the learned trial court that the predecessor in interest of the defendant purchased the land measuring 3 katas 18 lechas independently. But while reversing the finding, here the reason recorded herein is that in view of that, the learned trial court affirmed that the father of the plaintiff purchased the land over the same duct. Therefore, where the learned trial court itself affirmed the right of the plaintiff on scrutiny the evidence on record, determining the issue against the plaintiff is indeed wrong and need to interpret. But there is no finding that the Exhibit 6 document and Exhibit F document relied on by the defendant doesn't specify the land purchased independently by the predecessor in interest of the defendant.
No finding in respect of exhibit.
Exhibit F and Exhibit 6. No? So I have handed over a page explaining the amount of land that is involved in the suit and the land that is purchased independently by the predecessor in interest of the defendants, defendant number 1 to 5, and the remaining land is the joint land. So the finding is somehow perverse because while coming into conclusion that the land measuring so and so is the joint land or jointly purchased by the predecessor interest of the plaintiff also, it's somehow contradictory to the documents exhibited. Then continuing from there, page 107, the learned trial court viewed that the predecessor of the plaintiff relinquished his right over the suit land. He left the suit land and shifted his residence to some other place. The learned trial court denied the right, title, and interest over the suit land of the plaintiff on the principle of adverse version. The learned counsel appearing for the plaintiff appellant submitted that where the defendant respondent claim right over the suit land on adverse possession, the right, title, interest of the plaintiff appellant cannot be denied and it is admission by the defendant. In para number 52 of the impugned judgment, the learned court admittedly found that the suit land was not owned and possessed by the grandfather of the defendant respondent, Dhaneshwar Boda, but owned by Moheshwar Gogoi, Ramakanto Borua, and P.R.E. Mohan Borua jointly. This was not the finding of the learned trial court. The learned trial court has only held that in the Jamabandi record of in the year 1946, the land is jointly mutated in the name of the four of the sons of the predecessor in interest of the defendant and the plaintiff. The learned trial court did not say that it is jointly owned and possessed by the grandfather of the defendant respondent Dhaneshwar Borua. But the history of the case is that Dhaneshwar Borua and Mehula Gogoi, these two are two different persons. Mehula Gogoi was married to Moina Gogoi. So through the marriage of Mehula Gogoi and Moina Gogoi, Moeshwar Gogoi, the birth of Moeshwar Gogoi taken place. See, after the death of Mehula Gogoi, that is the husband and the father of Moeshwar Gogoi, Moina Gogoi remarried to Dharmeshwar Gogoi. মানে বড়ুয়া লিখে গগৈ লিখে বড়ুয়া sometimes he writes gogoi sometimes right বড়ুয়া no. So after her remarriage to Dhaneshwar Borua, she gave birth to 4 children, 3 children in fact. Ramakanta Gogoi, that is the predecessor in interest of plaintiff. P.R.E. Mohan Gogoi, that is the predecessor in interest of defendant number 6 to 8, and Saru Lora Gogoi, who died unmarried. So after her remarriage, Moina Gogoi brought back Moeshwar Gogoi to their house. So they started living jointly. And that's how 3 sons are appearing. That is Ramakanta Gogoi, P.R.E. Mohan Gogoi, Saru Lora Gogoi. Saru Lora Gogoi in fact died. In place of Saru Lora, Moeshwar Gogoi has come. So Moeshwar Gogoi purchased some of the properties independently, whereas some of the properties were purchased jointly. So far as joint property is concerned, there is no dispute. I am not denying their right on the joint property. So far as the property purchased independently by the predecessor in interest of defendant number 1 to 5 is concerned, I have an objection to that. And therefore, the learned trial court, while coming to the conclusion that plaintiff, defendant number 1 to 5 are the independent owner of a portion of land, dismiss the suit filed by the plaintiff, saying that the plaintiff doesn't have any right title interest over the land. If I may take your lordship to the schedule of the plain, it is very interesting. Page 23 of my memo of appeal.
Yes.
Land measuring 3 acres under DAG number 275, this is Schedule A, covered by PP number 73, and 1 biga, 1 gatha, 1 lecha under DAG number 274, covered by PP number so and so. Now, Schedule B is very interesting. Plaintiff's 1/3 share, land measuring 1 biga, 2 gatha, and Schedule A land. Which DAG, which patta? Plaintiff did not specify. From where he is seeking or from where he is deriving the 1/3 share has not been specified in the plain. Then Schedule C, under illegal and excess possession of defendant number 1, land measuring 3 katha in Schedule A total land. So total land is in the Schedule A, total land has been divided by 2 DAGs, 275 and 274, and as well as by 2 pattas, 73 and 120. The schedule is not clear. So in a partition suit, this is the mandate that plaintiff must aver in the plain specifically the measurement of the land and the specific boundary of the land from where he is seeking the partition. Then Schedule D is land under possession of the plaintiff, land measuring 4 katha in Schedule A total land. Which DAG, which patta? So for this reason, the learned trial court, having found that some portion of the land has been independently purchased relying on Exhibit 6 and Exhibit 5 document, came to a conclusion that the plaintiffs are not entitled to get the relief of right title interest over the plot of land. Then the next issue was issue number 7. It is in respect of our counterclaim framed by the learned trial court, whether the defendants has right title interest over the land, should schedule land. So the adverse position finding.
So this was, if the schedule B, then schedule D, land could not be identifiable. How the decree was passed?
Decree was, the suit was decreed because it was the bounden duty on the part of the plain as per order 6, the pleadings. The plaintiff has to aver categorically, specifically the land over which they are seeking partition. Since they could not prove that the land mentioned in Schedule A land, it is 4 bigha and odd or land, has been purchased and is the joint property of the predecessor interest of the plaintiff and the defendant, because they took a plea in the plain that there was a oral partition, by way of which a land measuring 1 bigha and 1 kata fell in their share in the middle portion of the land, whereas the northern side and southern side was divided, fell in the share of the defendant number 1 to 5 and defendant number 6 to 8. But since he was not in possession of the middle portion of the land, he was staying somewhere else, and the evidence also PW1, PW2 says that since 60 years after the 1940s, they did not possess that land. So their allegation is that we are encroaching upon the land which is situated in the middle portion of the both sides land of both the sides, and where we have started construction over the land. This is the only allegation. But so far as oral agreement is concerned, oral partition is concerned, they also fail to prove that there was any oral partition. So it was the bounden duty and the obligation on the part of the plaintiff to prove their own case that yes, there was an oral partition. By way of a oral partition, an amount of land measuring 1 bigha, 1 kata fell in the share of the plaintiff, and the other shares fell in the name of the other defendant. So there is a clear finding by the learned trial court that they miserably failed to prove the oral partition. So the next issue was issue number 7, whether the defendants have right title in the entire Schedule A land, including Schedule B land. Page 61 of the trial court delivery.
Yes.
DW1 Uttam Gogoi in his evidence and in amended written statement stated that Dhaneshwar Borua had 3 sons, namely Ramakanta Borua, alias Dihola, Pyari Mohan Borua, and Sarulora Borua. His deceased father was the son of one Mehuka Gogoi. After the second marriage of his grandmother with Dhaneshwar Borua, she gave birth of 3 sons, namely Ramakanta Borua, Pyari Mohan Borua, and Sarulora Borua. His grandmother brought his father and kept him with the family of Dhaneshwar Borua. The actual fact was told him after filing of written statement along with other defendants by an elderly person, namely Sri Chikun Gogoi. DW1 stated that according to the old revenue record, his father, Moheshwar Gogoi, son of Mehuka, independently purchased a land measuring 3 kata 18 lechas under Dag number 275. And his father's name was also mutated in the revenue record. Again, another plot of land measuring 2 bigha, 1 kata, 2 lechas under Dag number 275 was jointly purchased by his father, Moheshwar Gogoi, along with Ramakanta Borua, Pyari Mohan Borua, and Sarulora Borua. There we have no objection. Therefore, the entitlement of defendant number 1, DW1, and the defendant number 2 to 5 was 1/4 share, which was equivalent to 2 kathas, 15.5 lechas. DW1 further stated that his father also purchased land measuring 2 katha, 1 lecha under old DAG number 261, 244, new is 274, under PP number 274 so and so, Nij Goroimari. Remaining land measuring 4 kathas of land, DAG, had jointly purchased by his father along with Ramakanto Borua, Dighola and Pyari Mohan Borua. On the death of Moesher Gogoi, his legal heirs and successors are entitled to the land measuring 3 katha 18 lecha plus 1/4 of 2 bighas 1 katha 2 lechas which was purchased jointly. That is total land measuring 1 bigha 1 katha 13.25 lechas under present DAG number 275. Late Moheshwar Gogoi also independently purchased land measuring 2 kathas 1 lecha under old DAG number 261 344 and old periodic patta number 99 of village Nij Goroimari. The said DAG number 261 344 is now included in present DAG number 274. The remaining land measuring 4 kathas of the said DAG may have acquired jointly by late Moheshwar Gogoi and predecessor of the plaintiff as well as defendant number 6 to 8, namely Ramakanto Borua and Pyari Mohan Borua. DW1 further stated that name of Moheshwar Gogoi had been mutated in the old revenue record on 2841, being purchased the land from Ghano and Norendra. Therefore, defendant number 1 to 5 are entitled to 2 kathas 1 lechas plus 1/3 of remaining 4 kathas of total land measuring 3 kathas 7.66 lechas of land of present DAG number 274. Admittedly, both 274 and 275 are adjacent to each other. Late Moheshwar Gogoi had total entitlement of land measuring 2 bighas so and so lesser under aforesaid 2 DAGs. DW1 submitted that defendant number 1 to 5 were not occupying any share of land of heirs of late Ramakanto Borua and late Pyari Mohan Borua. Rather, the heirs of late Pyari Mohan Borua, that is defendant number 6 to 8, were enjoying the some portion of land belonging to the share of defendant number 1 to 5. As per mutual understanding, DW1 also stated that his father's name was recorded in the revenue record at purchaser on 2841 against the original pattadas Ghano and Norendra. Thus, the total entitlement of land by DW1 and defendant number 2 to 5 was 3 katha so and so lechas under present DAG number 274 and 275. Remaining suit land has been inherited by the plaintiffs and defendant number 6 to 8. DW1 further stated that there was an oral partition of the suit land long back amongst the parties. As per oral partition, DW1 and his deceased brother took separate possession of the land as per their entitlement had been living separately by constructing residential houses without having any dispute amongst the co-pattadars since long back. So for the share of predecessor of plaintiff and defendant number 6 to 8 in the suit land, there was also an oral settlement between them and both of them have been enjoying separate possession. In his cross-examination, DW1 stated that at first they filed written statement and counterclaim and had taken plea of adverse possession. Thereafter, DW1 and defendant number 2 to 5 had filed amended written statement, and in amended written statement, defendant number 1 to 5 had not taken the plea of adverse possession. Plaintiff's land was covered by PP number 73 and 102. DW1 himself was also a pattadar in serial number 3. DW2 in his evidence stated that the suit land measuring 3 bighas covered by DAG number 275 of PP number so and so and 1 bigha 1 katha 1 lecha covered by DAG number 270 under PP number 120 of village Nij Goroimari under Moja Goroimari situated in front of his house. The defendant number 1 along with his family member as well as the family members of late Pyari Mohan Borua had possessing the entire suit land. Defendant number 1 Uttam Gogoi was the son of Moheshwar Gogoi and Moheshwar Gogoi was the son of Mehuka Gogoi. The predecessor of the plaintiffs, namely Ramakanto Borua, and the predecessor of defendant number 6 to 8 were son of late Dhaneshwar Borua. He further stated that long back plaintiff's predecessor, late Ramakanto Borua, had gave up his share of the suit land in favor of his younger brother, Pyari Mohan Borua, and had settled about half kilometer from the suit land. In his cross-examination, DW2 deposed that the suit land was ancestral property of plaintiff and defendant. DW3 in his evidence stated that he knew both plaintiffs and defendant along with the suit land. The suit land was possessed by the heirs of Moheshwar Gogoi, that is defendant number 1 to 5, and the heirs of Pyari Mohan Borua, that is defendant number 6 to 8, since last 30 years. The father and husband of plaintiff had left the suit land 50 years ago and settled about half kilometer away from the suit land. The father of Moheshwar Gogoi, Ramakanto Borua and Pyari Mohan Borua were not same, rather mother was the same. DW3 further stated that he had knowledge about that suit land was purchased by Moeshwar Gogoi, Ramakanta Bora and Pyari Mohan Bora, but he did not know about the share. He also stated that Moeshwar Gogoi was expired on 1964. When Ramakanta Bora left the suit land, he had relinquished his share and gave to Pyari Mohan Bora. Thereafter, Pyari Mohan Bora had enjoyed and possessed his share and also Ramakanta Bora's share in the suit land till the death of Pyari Mohan Bora. DW3 further stated that after leaving from the suit land, Ramakanta Bora had neither come to claim the suit land nor the plaintiffs come to the suit land to claim their share. DW4 Dibjyoti Bora has deposed in his evidence that the predecessor of the plaintiff Ramakanta Bora was the elder brother of his father. DW4 and his co-heir had been possessing the share of the plaintiff since lifetime of his father for more than 30 years continuously, adversely and knowledge of the plaintiff. The plaintiff father left the suit land long back and settled about half kilometer away from the suit land. During that period, DW4 and his co-heir had made substantial development on the share of his father and as well as the share of the plaintiff's father. He admitted that the suit land was not originally owned and possessed by his grandfather Dhaneshwar Bora, rather part of the suit land independently owned by late Moeshwar Gogoi, Ramakanta Bora and Pyari Mohan Bora jointly. Drawing the attention of this court to the evidence of DW5, RKG branch DCO Sonitpur, in his evidence stated that Exhibit F is the Jamabandi book of 1930 of Revenue Village and Moja Goroimari. Exhibit F1 is the Jamabandi of Patta number 92. There was only one dag, number 258 in the said Patta. In the said dag, there were total 6 bighas 8 lechas land. Moeshwar Gogoi, son of Mehuka, was the original Pattadar at serial number 8. As per note dated 2841 of the said Jamabandi, land measuring 3 kathas 18 lechas was mutated in the name of Moeshwar Gogoi by way of purchase from Ghana and London. This finding was somehow set aside by the learned First Appellate Court without appreciating the evidence on record. That apart, land documents as submitted by the plaintiffs reveal that name of defendants are duly mutated in the records of right in respect to the suit land. The exhibits clearly reveals that the name of the defendants were duly mutated in respect to the portion of the suit land. There is mention of the name of Moeshwar Gogoi in contention of exhibits which are duly proved by PW3, the Lat Mandal under Charidwar Circle Office, and DW5. DW5, RKG branch, DC office, Sonitpur. Plaintiffs had submitted the revenue paying receipts of only the year 2012, that is the year when the suit was filed. But other receipts were not submitted, and in absence of other receipts, it cannot be said that revenue is regularly paid by plaintiffs. It appears from the document on record that the defendant side had exhibited the revenue paying receipt of the year 1978 to 2012. The defendant has exhibited those documents, which clearly establishes the fact that the defendant had been paying the land revenue. From the foregoing discussion of evidence and the reasons, it transpires that the document as submitted by the plaintiff reveals that name of defendant is duly mutated in the records of right in respect to the suit property as the legal heir of late Moeshwar Gogoi and late Pyari Mohan Bora. Exhibits also reveals the same. In the evidence, PW3 and DW5 clarifies that in the land record of the PP number 73 and 102 of so-and-so Moja, there is mention of the name of the defendant with the plaintiff. In the result, this court is of the considered opinion that the defendant have right title interest in this suit. So this issue was decided on the plea of our adverse position against the co-sharer. Because there are evidences to show that since 60 years, more than 60 years, he has not been in possession of the land. He has foregone his share and he has surrendered, relinquished his share in the name of the other brothers. This is one of the pleas taken by us. So issue number 8 was the issue whether the defendant have acquired right title interest. That was answered in affirmative. So to cut it short, if the appellate court judgment did not rely on or did not appreciate the Exhibit 6 and the Exhibit F document, which clearly establishes my right over a portion of the land independently, the finding of the learned First Appellate Court that the plaintiff is entitled to 1/3 share of the total land mentioned in the Schedule A, in my humble submission, may not be correct and it's perverse. So far as point of determination is concerned, the point of determination should be interpreted in a way that there is an independent finding given by the learned first appellate court. Whereas in the issue number 6, it is only mentioned that it should be interfered with because some languages here and there, and no independent finding has been given by the first appellate court so far as exhibit 6, exhibit 5 is concerned, so far as the issue number 6 is concerned. The only finding is therefore in issue number 6, therefore where the learned trial court itself affirmed the right of the plaintiff on scrutiny or the evidence on record determining the issue against the plaintiff is indeed wrong and need to interfere. This is the only reason why the finding in issue number 6 was interfered. And there is no finding. So point of determination should be interpreted in such a way that there is a finding on the issue already decided by the trial court. Merely quoting the paragraphs and coming to a conclusion that it needs to be interfered without any reason, in my humble submission, do not satisfy the requirement of Order 41, Rule 31. And since the entire land has been proved to be not the land of the predecessor interest of the plaintiff and the defendant, the learned trial court dismissed the suit, whereas it was reversed by the first appellate court without there being any reason. And the adverse possession plea was also set aside on the ground that there cannot be a plea of adverse possession against the co-sharer, whereas there are judgments to show that against the co-sharer also adverse possession is maintainable if you can establish through evidence or pleadings that the possession is hostile to the knowledge of the true owner, co-sharer, and if we could establish these facts with the evidence, then there is no reason in my humble submission for any interference by the learned first appellate court. And therefore, the substantial question of law regarding Order 41, Rule 31, point of determination, since there is no finding on facts regarding Exhibit 6 and Exhibit 5, and therefore it is perverse in a way that there is no appreciation of Exhibit 5 and Exhibit 6 document, which clearly establishes my independent right over the suit land. Yes. On the issue of adverse possession, I'm relying on a Supreme Court judgment 1956. P. Lakshmi Reddy. 1957 SC 314. I'm relying on paragraph 4. Now
No. Upon adverse possession, no substantial question of law was spread.
But under section 100 of the Code of Civil Procedure, if during the course of hearing, if your lordship feels, then Santosh Hazari case is very clear about this. Substantial question of law can be framed if at all required.
There is no doubt about it.
I leave it to your lordship. Just I am indicating. I'm just leave it to your lordship. If your lordship is satisfied that order 41, rule 31 has not been followed by the learned trial court, then your lordship,
No, that only on that one, the finding of the appellate court cannot be interpreted with. Because there is one recent decision, Mugendro Chitravan Mehta versus State of Gujarat or like that. I have forgot the actual name of the actual party. But it begins from Mugendro Indrovan Mehta.
but so far as non-appreciation of exhibit 6 and exhibit 5 is concerned, this is one of the vital ground which may be raised before this honorable court by way of perversity. Because unless and until that documents are appreciated to come out with the meaning that this document gives a right in favor of the different number 1 to 5, that could not have been set aside. Only
So on that point, there is no substantial question of law.
the lordship may very well frame the substantial question of law, because this is the question of law to be asked before this honorable court during the course of hearing. Lordship may frame that after perusing the records, that your lordship deems it fit to frame a substantial question of law, which is the non-consideration of evidence of exhibit 6.
That can be, but only after notifying both the parties.
Yes, yes.
Yes, Mr. Soleri? Pardon?
In another case, my learned friend is appearing.
No, regarding this substantial question of law, he urged that substantial question of law should be framed for non-consideration of the exhibit 5 and 6.
No, not necessary, Your Lordship, because that's the super latest judgment I've given yesterday.
Pardon?
Judgment I've given is there in the second following. I've given a judgment yesterday. Because how a second appeal should be treated, Your Lordship. It is in second file, it is there. I think second file they put the judgment, I think yes, put the judgment in second file. And a photostat copy of it. Kali yes. Kali put face judgment. Hey, judgment to back to the Polo judgment to judgment to us. I may take your lordship.
Yes, Hemavati and others.
Yes, Your Lordship. I take your lordship to page 6, Your Lordship. Page
Yes,
6.
yeah.
The jurisdiction of the High Court to entertain a second appeal is well known. It is a unique jurisdiction of the High Court where the High Court can entertain a regular second appeal purely on a substantial question of not even a question of law or a question of fact. It is a settled law that the first appellate court is the final court insofar as the question of facts are concerned, and it is only when substantial question of law would arise in a case that the High Court can entertain regular second appeal, and if at the stage of admission such substantial question of are discerned by the High Court, the same would have to be framed and the appeal would be heard, have to be admitted. It is only thereafter that the parties have to be heard on substantial question of law that are framed by the High Court at the stage of admission. At the stage of admission, Your Honor. However, CPC gives power to the High Court to frame additional substantial question or mold the substantial question already framed on hearing of the parties at the time of final hearing or a second appeal. In the event the respondent before the High Court are on record, even at stage of admission of regular second, the same is to be disposed of finally, even at a stage of substantial question must be framed and answered before regular appeal is admitted and disposed. On perusal of impugn order, we find that the same has been not been framed. The same error is compounded by the learned judge stating that the order passed in the review petition no such substantial question of appeal. In fact, it is necessary to highlight this aspect by quoting learned judge by what has been stated in para 3 of the order passed in the review petition so and so. Here I may skip this figure. The aforesaid paragraph would speak for itself vis-a-vis the infirmities in the impugned judgment and order of the High Court. If no substantial question arose in the case, then the appeal could not have been entertained and ought to have been dismissed at the stage of admission. But on the other hand, in the absence of a framing, any substantial question of the appeal has been allowed, that too at the stage of admission without issuance of notice
to the other respondent. Yeah, this is also important because a question of law, if you frame in absence of the thing on the other side also, in absence of framing a question, the appeal has been allowed. That too in a state of admission without issuing notice to other respondent and by hearing only the learned counsel were responded to before the High Court, who was on cavity. The aforesaid error is compounded by the fact that sum of rupees 50,000 cost was awarded to the successful plaintiff who had responded before the High Court in lieu of notices and so that's not required. The next para. In this context, the law on practice to be followed while considering regular secretary has been reiterated by this court.
No, Mr. Soduri.
Yes, Your Lordship.
You see, in this appeal,
Yes, Your Lordship.
they have taken the plea of perversity.
Yes, sir. Perversity cannot be question of law. Perversity cannot be question of law. Your Lordship.
On the ground of perversity, court can entertain second appeal.
No, perversity that can because it's a final question of fact. There's no perversity. I'll show it. Perversity is not there. They have admitted in the plain. They said.
No. Mr. Soduri, you see, the court has learned appellate court has not considered exhibit 5 and 6.
I'll address it out because what has happened in the plain itself, in the WS itself, they have admitted it's an ancestral property. I'll show it from there. In the WS itself. In the WS, they have admitted that's an ancestral property. If your Lordship turn to page 27 of the WS.
Page number?
Let me read my para here. Para 5. Page 13, if your Lordship, page para 13.
Page number?
Page number 13, 1-3.
31.
That the
30. Yes.
That the ancestor of the plaintiff and defendant late Dhaneshwar Barua. This is what Dhaneshwar Barua is a grandfather actually. Own and possess considerable landed property and particularly acquired 3 bighas of land, dark number 7 now covered by so and so bighas of land. And under dark number 2 said PP Patta, Vivek so and so under Moja Testwood in the district of Sonitu. Both the lands under so and so are adjacent to each other. The total land is 4 bigha, 1 katha, 1 lesa is fully described in so and so. Your Lordship, if your Lordship, page 27, if your Lordship see the reply there. Page 27. That their written statement counter claim. That in the my Lord has got it. Para 11, that investor ever in para 5 of the plain, that the ancestor of plaintiff and defendants, late Dhaneshwar Bora, own and possess considerable landed property and particularly acquired 3 bighas of land, dark number so PP Patta so and so on lesser, dark number 2 PP Patta so and so, Assam, and that both the dark number adjacent to it, thus comprise of 4 bigha 1 kata, are not denied. You know, this he has admitted this is an ancestral and 4 bighas 1 kata. This is
there is an amended written statement too, my lord.
No, amended, but he has contrary. He's
No. The amendment written statement I filed with the leave of the court under order 6 rule 17. So amended written statement will prevail over the written statement already filed.
How can it prevail?
But court has ordered, judicial order is there.
No, your Lordship, the question is, this was filed by all of them. This was filed, the second was filed by 1 to 5. Second was filed by 1 to 5 only. How can they go away?
No, Mr. Soduri, is there any bar in filing amended written?
No, there's no, but it cannot contradict it. How can they contradict the other earlier stand?
No, I have forgone my earlier written statement. That's why the amended written statement. What does it say?
But what about the other people? He is repairing 1 to 5. 6 to 8 is also there.
But the adverse possession claim is on my part. They are not claiming adverse possession and there is
no adverse possession is claimed by 6 to 8, not by him.
That makes the issue very clear.
No, you are not, if you are see, written statement counter on behalf of defendant. You see the page 26. It is written statement and counter claim on behalf of defendant. And this one is, if you are say written statement on behalf of defendant 1 to 5. How can this be discarded? Page 33, if you are choosing 1 to 5. My Lord has got it. It is different now 1 to 5. So how can it go? This WS will go ahead.
No, maybe.
Question is admitted fact is an ancestral property that I have to prove. And here for the first time he has taken the plea of purchasing the land. If your Lordship will see para 13 of page 34. What he says? This plot of land, dark number is 6 bighas and it's not 4 bighas, 6 bighas land. It says that the abutment, if your Lordship will see para 13, Page 30. That the averment made in para 5 of the pen are not absolutely true. It is denied that the answering because that Dharmeshwar owned and possessed considerable land and property, and particular 3 bighas of land, so and so Gavata, Dagna, Pirari Patta, and so and so Gorimati is submitted. Here he take a contrary stand. It is submitted that total land measuring 6 bighas. It is 6 bighas or not 4 bighas. 1 lesser of land, Dag number so and under Dag number so and the present period Patta 70 and so and so. And at present period village needs going. According to old revenue, Maheshwar Goi says this is Mahega is president of defender independently purchased 3 cut of land under Dag number so and so. And the remaining land of say Dag number so and so, your lordship. Here he has tried to confuse the whole issue. She has not given what the schedule, how from which schedule he has bought. The schedule is missing here. If the land is 6 bigha, not 4 bigha. The dark also 6 bighas of land. 6 bighas, if you lordship says it is somewhere it is 6 bighas, 1 less, somewhere it is 6 bighas, 8 lessers also. So here from there, if his same land is taken out also, the 4 bigha land remains here also. He does not get any party, any boundary also, your lordship. Just make a statement. Para 13, if you lordship see. Then he said, son of according to old David so and so, defendant independent purchase 3 kathas, 18 lessers. 3 katha, 18 lessers is fully accommodated in the 6 bighas land, your lordship. So it cannot, he cannot take the help of 3 bighas to enclose this land also. Because the plot is 6 bighas land. And there is, your lordship, they are saying, there is no relinquishment deed. Where is my question of relinquishment? If I relinquish, as per relinquishment deed has to be there, registered relinquishment. I have not relinquished. They are taking the plea, I have relinquished. Where is the document? Where is the document of relinquishment? I have not relinquished my share. They are saying that Dhaneshwar, but then later on they make a plea that all 3 brothers have jointly purchased the property. That plea is also there. So how can it happen, your lordship? So if your lordship will see that 3 katha, 18 lessers of land are the Dag number so and so, remaining land of say Dag so and so was jointly owned and possessed by Maheshwar Gogoi and so and so. So he again said, what happened by that thing? He want to enter this portion also. That 3 bighas is separate. That his land is nowhere connected 4 bighas and this thing, your lordship. He will enter. He is entitled to 1/3 share. That I am not disputed on that. And the fact that my legislature is saying that there is no, I have not given a schedule. I have stated in that northern part they have taken, southern part they have taken. I took the in between part. So that schedule is there. They are not denying the schedule. He is saying about he was reading the dispute about the schedule. How could the schedule be disturbed? Because when he says I hit the northern part, I have stayed in the plains also. That northern part they have taken up. I stayed in the plains also. Let's see. Para 7, page 13. That during my lord has got that during the lifetime of late Maheshwar Gogoi, Ramakanta Gogoi, late Paraman Gogoi, all sons of late Dimeshwar agreed to divide 4 bighas, 1 katha, 1 lesser of land, describing schedule equally with respective shares of 1 bigha, 2 katha each. According to late Maheshwar Gogoi and late Pyari Mahanu opted to take the northern and southern part of 1 bigha, 2 kathas of land, respectively, leaving the middle portion of the 1 bigha of land and late Ramakanta husband of.
No, even then that portion of the land has the Dag number, Patta number.
Yes, no, that is here. That is given here, your lordship. Dag number is here. Schedule is giving the Dag number.
No, are you not supposed to give the schedule of that land?
No, that because here I have given a schedule is here. Schedule is here, your lordship. Schedule I have given here.
No, where you have mentioned that that schedule is also the part of Schedule A or Schedule B or like that.
Schedule A is the entire land. Schedule A is the entire. Schedule B is my portion. If your lordship see, if your lordship turn page 23, if your lordship see, land measuring. Land measuring 3 bigha, the Dag number 275 and PP number so and so, and 1 bigha katha, so Dag number so and so covered by village so. It says good. This is your lordship, that schedule is given here. So it is 4 bigha and this thing. Then if your lordship turn this thing, schedule B is a land measuring 1 bigha so and so, schedule a total land. This is my share, your lordship. Then schedule C says under illegal access possession defend our land measuring 3 kathas in schedule A suit land. Then D is saying land under possession of the plaintiff. This D is in under possession, Schedule D. So what they have encroached by portion of land. That's the dispute is that they have encroached by portion. That is a dispute, Your Lordship. They have illegally encroached by land. That is a dispute, Your Lordship. They have not said they are. It is not the case. I am not there in the land.
Okay. So according to you,
Yes, sir.
no additional substantial
No, not
question required to be framed.
Not necessary.
Not necessary.
Not necessary. Your Lordship.
Okay. So, Mr. Mukherjee, you want to argue the matter?
Lordship, just one small thing because time may not permit. One small thing just was striking me. The suit was dismissed, Your Lordship. Suit was dismissed, so the question of this schedule and everything, as it was dismissed, how it is to be executed, the question did not arise. However, in the appeal, as the suit as filed by them was for partition of the whatever they are saying to be the ancestral property. If it is a partition suit, when it is decreed, Your Lordship, there has to be a preliminary decree, and then it has to be finalized by a final decree. Whatever I understand, my limited understanding, Your Lordship. If the schedule was not proper as to what 1/3 share they are claiming, but the DAG number and patta number of that 1/3 from which DAG and patta, if the schedule is not clear, whether the appellate court which decreed, and even in the decree, Your Lordship will see, if I take Your Lordship to the decree, all the issues are thoroughly discussed, Your Lordship, and at the end, Your Lordship, at the last of the judgment, the appeal is allowed on contest. The judgment and decree dated so and so passed by the learned Municip number 2 Tezpur is hereby set as prepare a decree accordingly. Send down the case record of TS number to the court of trial with a copy of this judgment and decree. Let the judgment be furnished. Where is the question of preliminary decree here?
Preliminary?
The preliminary decree was not formulated. So if the suit was dismissed, the dismissal was set aside, and the suit was decreed by the appellate court. The appellate court, while decreeing a suit or whatever they are saying is a partition suit, there had to be a preliminary decree first, and on the basis of that,
Not a partition, my friend. Not a partition.
they are claiming 1/3 share of the total.
It's not a partition, just see the prayer. That the suit be decreed that the original and is ancestor property of plaintiff and that the plaintiff is entitled to 1/3 share. It's there. Prayer, page 22 onwards. Clearly specified, 1/3 share.
Yes, partition.
1/3
The
share.
claim-
In terms of this prayer, he has decreed.
How will this decree be?
How can it be 80 why it is executed? Why not? The land is there.
In this ground, what I am suggesting now, Your Lordship, another substantial question of law may be required, Your Lordship, because whether the final decree could be passed by the appellate court in absence of a proper description of the Schedule B and Schedule C land. Because they have prayed, if I assume that the appellate court's decree was proper, if I assume without conceding, the decree will have to be executed. They are saying they're entitled to Schedule B land, which is 1/3 of the Schedule A land. Now, Schedule A is a plot of land comprising of two separate plots of having separate dag and patta. One is 1 bigha, another is 3 bigha, Your Lordship. So, how far this Schedule B, which they are claiming to be 1/3 only, where from this 1/3 will be given to them? There is no.
Your Lordship, the two plots are contiguous. They schedule this 278 they are contiguous in nature. It's not separated. That it can be carved out from there, but there is no problem. It is not far away. It's not like my narrator is trying to put 270 was somewhere, 270 is somewhere else. It's not like that. They are continuous to, they have admitted it continuously.
So from-
and it can be earmarked from there.
From one dag, maybe this portion would have been to them, to their effect. From another dag, this portion. Where is that distinction?
This is the dags are there.
Without
share,
that-
we are claiming a share. That it is an ancestral property. There is a question of sharing. I am claiming my 1/3 share. It's not a civil suit that you are decreeing that on the. It's a partition thing which I am entitled to my share. That's all. 1/3 share.
So there, in my understanding, there had to be a preliminary decree first, and then
That are not necessary.
that I suppose
Not
that I
necessary.
suggest that there may be a further substantial question of law in that regard as well. And regarding the other substantial question of law, that was framed in my case, the second case, Your Lordship. The third substantial question of law takes care of that adverse possession thing, Your Lordship.
Because adverse possession is a question of fact, not a question of law.
No, that is mixed question of facts and.
But mixed question is not a substantial question of law, that's all your lordship. Mixed question of law doesn't give rise to a substantial question of law, your lordship. These judgments is very thing.
And while deciding the issue number 2, Your Lordship, whether and against that counterclaim also, Your Lordship, there was no written statement filed by the plaintiffs. They have admitted that they have not. Against and there is another perversity, what I was pointing out while speaking about adverse possession. While deciding the issue number 2, the appellate court has made a categorical finding.
On adverse possession, no substantial question.
The third substantial question of law in my case, Your Lordship. Whether the learned first appellate court justified in deciding issue number 13 and decreeing the suit by dismissing the counterclaim in contravention of section 27 of Limitation Act.
No, lordship, I mean, its ability will vary. I'll return your. Ability will vary.
Okay, furnish a copy to him also. Let's adjourn the matter.
Your lordship.
Adjourn the matter.
Let it part her.
Part heard, yes. We'll keep it as part heard. Heard Mr. Has discussed learned counsel for the appellate in RSN number 17 of 2024 and the Mukherjee for appellant in RSN number 26 of 2024 and Mr. Chaudhary for respondent in both the cases. Both the cases. Heard in part.
Yes,
This the matter. After vacation.
5th August.
5th August. Okay. This the matter is part of. So on that day, we will also consider this framing of additional.
We'll see. I'll satisfy that. Because no need to provide message. That also I'll see.
Yes, yes.
Eight can have why have we saw that? This is 50. 53, 8 and 7,
27. Much obliged. My lord.
27.
Lordship, can it be taken up, can it be taken up after vacation, Lordship?
After?
Vacation, Lordship.
After vacation. Mr. Singh, learned counsel for the applicant, Mr. Appellant, guys who are listening the matter after vacation. They are allowed recess unless the matter immediately after reopening of the vacation.
Lordship, date may be fixed, Lord.
7th August. 7th August. 10/28.
May it please your lordship. My lord, I have seen my learned friend has placed a chart.
That is the wrong chart I have given. That is not there, Malad. This is wrong chart. Because I thought 1/3, later on from the record, it reveals that only daughter was there. So it will be, my lord, 50. Because these are, from the record, it seems that the respondent number 2 and 3 are.
But the deduction will be, my lord, since it is bachelor, deduction will be 50%. And regarding others, my lord, your lordship kindly see, is an appeal filed by us. They did not file any cross objection. So therefore, my lord, in my appeal, they cannot claim for any enhancement. My lord, I will take your lordship to decision of the Honorable Appeals Court to clarify this position. It is same these, then others to, my lord, my lord, just 1 minute, I am just trying to. So, pharmacy My lord, we are trying to, my lord, sort it out, whether it can be, my lord, settle it here.
Yes.
My lord, he want, multiplier was taken.
17.
17.
17. It should be
17.
18.
Now it is 18. It is in terms of the law. That is the position is correct. And so for love and affection, my lord, he wanted. Love and affection, Appeals Court said it is not maintainable. And funeral expenses, my lord, as the, in terms of the decision of the Appeals Court, your lordship can give it. So only this part of the modification.
Concentrating is there also. Concentrating. And concentrating is there, my lord.
On these points, my lord, although my lord, the Appeals Court has said unless they file an appeal, my lord, your lordship will not like to enhance on those points. But then these are the points which conventional and future process, these things are settled. So therefore possibly your lordship can enhance to that
Yes.
extent.
That is my.
Otherwise, my lord, enhancement in our appeal by them is prohibited by the decision of the Appeals Court as well as by this court. But then so far, these conventional and all that, I will not say that, because these are already been, my lord, settled by this court and Appeals Court. So what they want, the calculation is not correct, my lord.
Yes.
This will have to be corrected.
Yes, that is to be corrected.
So
Because
let
I have
us,
given 1/3, it should not be 1/3, my lord, because daughter was there. So mother and daughter will get it.
deduction will be 50%. We shall calculate that, and multiplier will be 18.
Yes.
It is okay.
This okay.
And love and affection, they will not get. Future prospect 40%, that is okay. And funeral expenses, that can be given. That's all.
No,
You correct it.
no, correct it. Because love and affection was given for minor. No, that's okay. The trial note is given for that for minor. That was.
No, but that is not permissible.
Yes,
in
that,
view of
that,
the
that I,
decision of Supreme
that
Court.
is it.
Acha, Mr. Dutta, you show me the decision of Supreme Court where it is stated that they cannot claim enhancement.
Love and affection.
No.
Announcement of.
Oh,
appeal.
oh, yes.
Without a
Right.
cross objection being filed,
Yes,
they
yes.
cannot claim enhancement.
My lord, I'll just giving to your lordship. There are two decisions I'll be placing. This paragraph, how much? You please. This.
Learned friend will submit that, but I'll submit our High Court's decision, my lord. Why justice difficult to, where it said in absence of also cross objection, it can be enhanced.
My lord, 2011-14 SCC 639.
SCC.
I'll take your lordships to paragraph 7 and 8.
2011.
2011.
Yes.
14 SCC.
14 SCC.
639. Paragraph 7, my lord. This principle also flows from Order 41, Rule 33 of the Code of Civil Procedure, which enables an appellate court to pass any order which ought to have been passed by the trial court and to make such further or other order as the case may require, even if the respondent had not filed any appeal or cross objections. This power is entrusted to the appellate court to enable it to do complete justice between the parties. Order 41, Rule 33 of the Code can, however, be pressed into service to make the award more effective or maintain the award on other grounds or to make the other parties to litigation to share the benefits or the liability, but cannot be invoked to get a larger or higher relief. For example, where the claimant seeks compensation against the owner and the insurer of the vehicle and the tribunal makes the award only against the owner or an appeal by the owner challenging the quantum, the appellate court can make the insurer jointly and severally liable to pay the compensation along with the owner, even though the claimants had not challenged the non-grant of relief against the insurer. Then para 8. Where an appeal is filed challenging the quantum of compensation, irrespective of who files the appeal, the appropriate course for the High Court is to examine the facts and by applying the relevant principles, determine the just compensation. If the compensation determined by it is higher than the compensation awarded by the tribunal, the High Court will allow the appeal if it is by the claimant and dismiss the appeal if it is by the owner insurer. Similarly, if the compensation determined by the High Court is lesser than the compensation awarded by the tribunal, the High Court will dismiss any appeal by the claimants for enhancement, but allow any appeal by the owner insurer for reduction. The High Court cannot obviously increase the compensation in an appeal by the owner insurer for reducing the compensation, nor can it reduce the compensation in an appeal by the claimant seeking enhancement of compensation. So therefore, my lord, unless they file an appeal or process objection, my lord, in our appeal, they cannot claim it. The next, my lord, I will take your lordship to 2003 9 SCC, page 606. Lord, paragraph your lordship may note, paragraph 13 and 15, my lord. Para 13 at page 618. Lordship got it.
13 and
13 and 15,
13 and 15. Yes.
my lord. I'm reading 13, my lord. We are therefore of the opinion that in the absence of cross appeal preferred or cross objection taken by the plaintiff respondent, the first appellate court did not have jurisdiction to modify the decree in the manner in which it has done. Within the scope of appeals preferred by the appellant, the first appellate court could have either allowed the appeals and dismissed the suit filed with the respondent in its entirety, or could have deleted the latter part of the decree, which granted the decree for specific performance conditional upon failure of the defendant to deposit the money in terms of the decree, or could have maintained the decree as it was passed by dismissing the appeals. What the first appellate court has done is not only to set aside the decree to the extent to which it was in favor of the appellant, but also granted an absolute and out decree for specific performance of agreement to sell, which is to the prejudice of the appellant and to the advantage of the respondent, who has neither filed an appeal nor taken any cross objection. Then your lordship may kindly see paragraph 15, my lord. They have given, my lord, 3 conditions. Now 15 speaks, the rule 4 seeks to achieve one of the several objects sought to be achieved by rule 33. That is avoiding a situation of conflicting decrees coming into existence in the same suit. The above said provisions confer power of the widest amplitude on the appellate court so as to do complete justice between the parties, and such power is unfettered by consideration of facts, like what is the subject matter of the appeal, who has filed the appeal, and whether the appeal is being dismissed, allowed, or disposed of by modifying the judgment appealed against. while dismissing an appeal and though confirming the impugned decree, the appellate court may still direct passing of such decree or making of such order which ought to have been passed or made by the court below in accordance with the findings of fact and law arrived at by the court below, and which it would have done had it been conscious of the error committed by it and noticed by the appellate court. While allowing the appeal or otherwise interfering with the decree or order appeal against, the appellate court may pass or make such further or other decree or order as the case would require being done, consistently with the findings arrived at by the appellate court. The object sought to be achieved by conferment of such power on the appellate court is to avoid inconsistency, inequity, inequality in relief granted to similarly placed parties and unworkable decree or order coming into existence. The overriding consideration is achieving the ends of justice. Why did the power hire the need for caution and care while exercising the power? Usually the power under Rule 33 is exercised when the portion of the decree appeals against or the portion of the decree held liable to be set aside or interfered by the appellate court is so inseparably connected with a portion not appealed against or left untouched that for the reason of the latter portion being left untouched, either injustice would result or inconsistent decrees would follow. The power is subject to at least three limitations. These limitations are very important. Firstly, the power cannot be exercised to the prejudice or disadvantage of a person, not a party before the court. We are not concerned with first one. We are concerned with second and third. Secondly, a claim given up or lost cannot be revived. And thirdly, such part of the decree which essentially ought to have been appealed against or objected to by a party and which that party has permitted to achieve a finality cannot be reversed to the advantage of such party. A case where there are two reliefs free, for and one is refused while the other one is granted, and the former is not inseparably connected with or necessarily depending on the other. In an appeal against the latter, the former relief cannot be granted in favor of the respondent by the appellate court exercising power under Rule 33 of Order 41. So, my lord, in this case, possibly these questions, very strictly speaking, whether your lordship can enhance on these 2 points. I think that cannot be very strictly come up because these are conventional head and one is let me see your chart. One is conventional head and one is a wrong multiplier. Hello, this the multiplier wrongly chosen, very correct. In place of
18, 17 there.
17, no?
No.
It should have been 18.
Instead of 18.
In place of 17, it should have been 18. There is a position of law, my lord, in terms of Sharla Barmaski.
Yeah.
So your lordship can, since it was incorrect one, your lordship may correct it. And so for consortium and funeral expenses, it was not given.
No.
It was not given, your lordship can give it because conventional head your lordship has seen, they automatically get it. So my lord, I am not arguing all those things. So your lordship can enhance these in 2 grounds, my lord.
So this is the ground which are sought for.
And
For
in
enhancement on that ground.
And so for 50, 1/3, you want
One
that,
third.
that
No,
will-
that is not there.
That's-
Because though he is a sole bread earner, but sister was there. Two brothers are there. They were earning. I have seen from the record evidence, my lord.
So deduction of 50%, that is correct.
Correct. So for the minor girl is the sister is there.
And
Mother and sister.
your
That has
chart,
to be there.
your chart you have given love and effect.
That has to be taken. That has to be there. Love and affection.
My lord, let my learned friend give a correct chart and can place to your lordship's, my lord. To limited extent, your lordship can enhance it.
When? Yes.
Nothing,
No, nothing else.
nothing else.
This is only this is the one which have come for.
When you are going to give the chart.
Tomorrow morning I will hand it.
Let
The
him give a copy to us and
Yes. Multiplier will be 18, my lord. That love and affection will be deducted. Funeral expense. Lost to
As
get.
per that decision of Supreme Court in Pronoy Sati.
yes,
Yes,
Their calculation is given.
yes, my lord.
right.
Then when the accident took place,
Accident took place, my lord. Excellent. Wonderful. Excellent judgment. It is award of 14.
2014.
The award was given 2014.
No. When the accident took place.
Accident took place prior to that.
25/8/2010.
10.
That.
I'll give you the calculation tomorrow morning.
So there's a compensation under the conventional heads. They has to be increased by 10%
Yes.
after every
Every 10 years.
three years.
10 years.
You calculate that one.
Yes.
So we'll list the matter tomorrow again.
Better, my lord, your lordship may fix. And another point, my lord, your lordship wanted, other day, my lord, my learned friend was here. Your lordship wanted a clarification regarding interest on future prospect. My lord, I'll place this decision to your lordship. Another one. I think my learned friend is aware of that position. In paragraph 21.
No, that is well settled.
That is well settled.
Yeah, well,
You will not entitled.
No, that,
yes.
no, that's why.
My lord,
I'm
should
not
I,
claiming
should I
to
place a judgment on that? He is not
Oh,
claiming up.
right.
Not claiming that also.
All right,
So tomorrow at 2 p.m. then.
right.
You
PM, my lord.
heard Mr. S. Dotto, learned senior counsel, assisted by Mr. S. Dotto, learned counsel for the appellant, and Mr. Bhattacharya, learned counsel for the respondent number. Mr. Bhattacharya, you were for respondent number
Respond number.
1 to
1.
1 to 4.
1 to 4. And Madam, you for? Respondent number 7. Hardin Court, leaves the matter tomorrow at 2 p.m. So, Mr. Dotto, regarding this enhancement of the amount without cross objection,
My lord.
but there are some subsequent decision of the Supreme Court perhaps where it is stated that court has to decide the
My lord,
just compensation.
just.
My lord, our High Court was also given a judgment. I will place it tomorrow by Justice Devashish Borua recently, my lord. His lordship has said, my lord, we have that.
My lord, I have placed one judgment.
Just 1 minute, my lord.
2003 of our High Court. By Justice this moment.
I am having that. I am just, this honorable court has said, so far the settled position of law, that is like conventional amount, future prospect, these are already been settled. There is no point of argument. So therefore, in that particular case, it is, I'll place this judgment tomorrow to your lordship. Future General India Insurance Company Limited by versus Bobby Bora. His lordship has said, we took the claimant took a ground that without my lord filing their appeal, cross appeal, they said in place of 10,891 monthly salary, she is to get 15,000. But the honorable court has said, so far those things are concerned, you must have an independent appeal because we shall have to go entirety of the thing. But then conventional amount and all other things, that can be given because these are settled. There is no point of argument by either of the side. That decision in paragraph 33, I'll place this judgment tomorrow.
Okay.
29.
Obliged.
Obliged.
May I please your lordship? May I please your lordship? Lordship, here we have filed the petition number 4 here.
So the time is about to. What to do?
They have filed few IAs, your lordship, for substitution and abatement.
When?
Lordship, we have filed it on 11 June.
There is a delay in filing this substitution.
Lordship, there is a delay of 1047 days.
You received that copy?
Yes, your lordship.
Any objection?
No objection, lordship, can be condoned.
Heard Mr. W. Hawk.
Lordship.
Learned counsel for petitioner. The applicant and Mr.
H. Budagohain.
Gohai for respondent number,
All the respondents.
sole respondent, this application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 147 days in filing connected substitution petition seeking to impede the legal heirs of deceased petitioner number 4, namely Shri Surinder Singh Gulati. Mr. Hawk learned counsel for the applicant submits that the petitioner number 4, Surinder Singh Gulati, suffered demise when
Lordship on
on
Lordship on 16/3/2021.
16/3/2021.
Lordship.
16/3/2021. And when you have received the information,
Lordship, on the last occasion when the matter had come up before this court, then actually petition number 4 was the person.
you tell me on which date you came to know about it.
Lordship, on 27/5/2025.
And that he came to know about the demise of respondent number, no, petitioner number 5 on 27/5/2025. Then immediately knowing about the same, he filed this application. No, file application for substitution along with the petition for condonation of delay. Mr. No, and the delay is not intentional, and therefore it is contended to set aside, no, contended to condone the same. So while learned counsel for the respondent submits that he has no objection. We are taking note of the submission of learned counsel for the parties and also considering the fact of the record. Condonation, delay of 1047 days stands condoned as the same appears to be sufficiently explained in the petition. Or this substitution. This substitution petition under Order 22, Rule 3 of the Code of Civil Procedure is prepared by the legal heirs of deceased. Filed by the applicant for substitution of legal heirs of the deceased petitioner number 4. Namely Surinder Singh Gulati. Mr. So learned counsel for the applicant submits that the petitioner number 4 suffered demise on and he came to on 16/3/2021 and he came to know about the same on 27/5/2025. And the said petitioner number 4 left behind how many
3
legal heirs are
Lordship,
there?
3 legal heirs, his wife and
Left
2
behind 3 legal heirs, namely Gurmeet Simati Gurmeet Kaur, Pravinder Singh Gulati and Harvinder Singh Gulati, and they are required to be implemented as petitioner in place of petitioner number 4. Mr. Guhai, learned counsel for the petitioner, no, respondent submits that he has no objection. They are taking note of the submission of learned counsel for both the parties. And also, considering the facts and circumstances of the record, this interlocutory application stands allowed. The name of 3 legal heirs of respondent of petitioner number 4, they implemented as petitioner in the CRP number 295 of 2014. In view of the order passed in I number 7, the learned counsel for the petitioner filed amended clause title within a period of 1 week from today.
Lordship, there was also a petition under Order 22, Rule 9.
Setting aside.
Setting aside. Deeply obliged.